All right. Ms. Rivers, are you ready? Great. Mr. Lowe, can you hear me?
Yes, sir.
Great. Good morning.
Good morning.
Let's get on the record in 10. It's 10 SC 92615, State versus Lowe. We have several attorneys from the district attorney's office here on behalf of the state and several attorneys from the public defender's office on behalf of Mr. Lowe. Two things I think we're covering this morning, and then anything else we need to ensure that we are as ready as can be for our upcoming trial date are, number one, the defense motion in limine to exclude expert testimony from either Dr. Shao or Dr. Subramani, or both. And then we have a long-standing or long-pending motion to suppress a statement that Mr. Lowe allegedly gave to law enforcement. Both those were calendared for today, so hopefully we can move forward with those. Let me start with Ms. Love. Good morning.
Good morning.
Was there anything else you were thinking we would cover today?
No, Judge, I think that was it.
Okay.
That was it.
All right. And good morning, defense team, and welcome back, Ms. Primovic. I understand you were out for a little while. Glad you're back. Ms. Shubo, what else are we covering, if anything, for Mr. Lowe?
We still don't have a witness list, so just letting the court know that.
All right. So we'll say discovery,
Yes.
and then the two motions. I see that we have, I'm guessing that SR Benton is Detective Benton online. Did the sides agree that SR Benton can appear virtually? No. Okay. Are you, well, let me do this before we go any further. Do you, Ms. Shubo or Ms. Primovic, waive Mr. Lowe's personal physical in-court presence? He's with us on the screen. He and I have already interacted. He pleasantly said hello. I did the same. But he is at Georgia Regional, which I think is by your request. And I want to get on the record that there's no issue from the defense that Mr. Lowe is there and not here.
Correct. We have no issue.
All right. No issue with Mr. Lowe. Assuming SR Benton is Detective Benton or whatever rank she is now, did you agree that she could appear remotely?
No. The first we heard of it was this morning when Ms. Love asked for the Zoom link for Detective Benton.
Okay. Do you object to Detective Benton appearing remotely?
I don't object to her appearing remotely, but I wasn't prepared for that. So I have things to confront her with that aren't electronic, and I don't know how to do that.
If we are able to work through that, we may be, because I think I still know how to make the Elmo work.
Okay.
Are you willing to give it a try? Note to state, don't have witnesses appear virtually without giving the other side more than this morning's notice, because they may agree, and it sounds like Ms. Shubo is going to try to be flexible here, but they certainly don't have to agree on the criminal side. And that's both directions, but today it's the state that pulled this fast one. So let's see what we can do with that. Is it lots of documents? Is it a video? What do you have? Okay.
I want her to possibly, I mean, depending, the state's going to ask questions, but my thought is we would want her to read her police report if she doesn't already have a copy with her, and then respond to questions regarding it.
So I'm going to ask Ms. Love in a minute if she's got it. I bet she does, because that looked like what Ms. Love wanted to say. But if what we do is your other motion first, then I can have the state make sure that, is it still Detective Benton? That Detective Benton gets it. In other words, that it's emailed, faxed, carrier pigeon, whatever it takes, so that she's got it. That doesn't mean you still can't try to confront if you want me to figure out the Elmo thing. But if she's got what you've got and you say, look at page 7, why does it say here Mr. Lowe was non-responsive, whatever it is you want to ask her about, then we're literally all on the same page, except for me, because I don't have it, but that's okay.
Yes.
All right.
We don't, if we could work out, go to page 7, look at that, and we're all in agreement as to what page 7 is, then I don't have a problem.
Okay. Can you bend the microphone back in and towards you and make sure it's green? Excellent. I want to make sure Mr. Lowe can hear everything. Ms. Rivers can, because she's here in court with us. All right, why don't we, let me ask Ms. Love, do you believe that Detective Benton has whichever report we're talking about? And she may have done 100 reports if she's the lead detective in a homicide, but do you know the report to which Ms. Shubo is referring?
Ms. Shubo let me know right before we got the court to the bench that as long as we have an electronic copy of the file that we can put up and share our screen with Zoom on, that she can do what she needs to do with Detective Benton. What I told her and what is true is that we have on our server the entire file, and I just joined Zoom so that with Ms. Shubo's direction, I can pull up any file or any part of the file that she wishes that I do and share it with Detective Benton.
Got it. So Detective Benton may have her report, but if she doesn't, you'll be able to get page by page, whatever it is you or Ms. Shubo wants Detective Benton to be able to look at.
I could, correct. I
Great.
could let her hold it and, do what she needs to do with it.
Okay. All right. Excellent. Well, hopefully that'll work. But let's still focus on the motion in limine first. And Ms. Shubo, don't let me forget, if I say, great, we did motion in limine and motion to suppress, we're done, we need to talk about the witness list. Okay. All right. Yes, ma'am.
So, Your Honor, I was going to ask, I know that the court asked whether or not it would make sense if we did one over the other first, and if the court directs us, I'm going to do what the court directs. But Detective Benton is on site with another special prosecutor doing a whole other thing. And if the court permits and if Ms. Shubo has no objection, I'd ask that we do the Jackson dinner part.
That's fine. What is it on site? Isn't she's in the DA's office somewhere?
No, off site, like at a place in Hateville.
Okay.
There's some boxes.
With a special prosecutor. Is that someone not in your office, or it's a special person from your office?
She is someone who was in our office and who is now with PAC, but has been deputized.
All right. Excellent. Okay. Ms. Shubo, then let's swivel, and we will handle the motion to suppress the statement, which I need to get my hands on.
Your Honor, would you like a discovery packet so you can follow along?
If it's going to be on the screen, I can follow along well that way. All right, I'll be right back. I was looking at it and I may have pulled it out of my flow stack and left it on my desk.
This is what I'm talking about. The first piece of the cover page, so I have 534 in your discussion.
And that's all you need.
Yes, I mean, if you need to pull up that, that's fine too, but this is all that I'm going to need to possibly.
I'm gonna go ahead and so
I think
Good morning again.
well, I think that's the, I think that's.
All right, I'm back. I did leave it on my desk. So I have in front of me the December 20th, 2021 motion to suppress defendant statements. Is that the motion we're talking about, Ms. Shubo?
That is the motion we're talking about.
Okay. And It focuses specifically on a statement that Mr. Lowe allegedly gave on April 5th in 2010. He had declined to speak with officers based on the information you have. He'd been Mirandized. I don't want to talk to you. So they're taking Mr. Lowe to the patrol car. And as I understand it, there's a sua sponte. And by the way, I'm going to beat this one. I've been acquitted of this before. I'll get away with this one as well. That's the statement you want out. Or is there more?
Well, that's the only statement that we know of. I don't know if Detective Benton knows of other things, but anything that was post the invocation of rights, or honestly, we just don't know what statements he made because they're not in the police report and they're not in the prelim transcript. So if there are other statements that might come out from the day in question, from the 5th, we have the same kind of voluntariness issue with regard to his mental status.
Sure.
This is the statement that we currently know about. So the testimony may enlarge that.
Okay. Sure. If it's enlarged via testimony, if at trial someone says, oh, another thing Mr. Lowe told me, and you hadn't heard about that before, it's suppressible for a different reason because it wasn't disclosed. And it should have been. So we'll cross that bridge where if we hear a witness say, oh, a law enforcement witness, another statement that Mr. Lowe made, people need to stand up or raise their hand quickly and we'll pause and work through that. But I just want to make sure I understood the universe. Right now it's a very small universe. It's whatever any witnesses who might remember having their recollections refreshed 12 years later, whatever Mr. Lowe said after he invoked his rights on April 5th.
Yes.
Okay.
And if there's some spontaneous utterance before he invoked his rights that is also subject to it being involuntary because of his mental status, we want to address that too. We don't see that in any of the reports.
Okay.
So I don't think that exists, but if it does, we think, our argument is on the 4th, he was not guilty by reason of insanity. If he was insane, at the date and time, then his statements our argument is should, but may be all involuntary.
All right.
The one statement we wrote about is the statement we're most interested in at this point.
All right. All right. Well, then why don't we get started? Do you have any questions or you think you understand the parameters of what the defense is trying to suppress here, Ms. Love?
I understand the parameters of what they're trying to suppress. Any questions that I have go to, or comments that I have deal with the argument about.
Sure. Okay. Well, let's get the facts on. You want to call your witness?
Yes, ma'am. Can you hear me okay? The state calls Detective Summer Benton. Detective Benton, are you unmuted?
No, I can hear you.
Okay, good deal. All right. Your Honor, would the court have me to swear in Detective Benton or?
No, I would have Deputy Gordon do that. And I'm going to, with your permission, Ms. Shubo, de-spotlight your client and put the spotlight on Detective Benton in the Hateville box room.
Yes, that's what I was going to ask if you hadn't, so I appreciate it.
Okay, done.
Can you raise your right hand? Do you swear or affirm that the testimony you will give will be the truth, the whole truth, and nothing but the truth, so help you?
Yes, I do.
Lower your hand. State and spell your name for the record.
Summer R. Benton, that's S-U-M-M-E-R. R is my middle initial. Benton, B as in boy, E-N-T as in Tom, O-N.
Good morning, Detective Benton.
morning.
Thank you for joining us. Detective Benton, would you please state for the record where it is that you are currently employed?
City of Atlanta Police Department, Homicide Unit.
How long have you been employed there?
I've been with the Atlanta Police Department for over 20 years, and I've been with the homicide unit now for 13 years.
What is your position with the City of Atlanta Police Department Homicide Unit?
I'm a detective.
Are you certified as a law enforcement officer by the state of Georgia?
Yes, ma'am.
Have you remained certified, certified during the entirety of your tenure as a homicide investigator with the
Yes,
City of
ma'am.
Atlanta?
Yes, ma'am.
Were you assigned as lead investigator on the homicide involving the victim, Joseph Giddens?
Yes, ma'am.
And during the course of your investigation, did you have an occasion to interview the defendant, Daryl Lowe?
Yes, ma'am.
Do you recall the date of that interview?
Can I look at my notes or the report that you guys?
Yeah, so
You can look at anything you want. You need to let us know what it is. And if it's something that the defense doesn't already have, one, that's an issue, but two, we'll need to understand what it is you're looking at. So if you could just describe what you're looking at, and it may well be the 14-page report that everyone wants you to have in front of you.
I only have the initial report in front of me right now. It was April 5th, 2010.
okay.
Your Honor,
Is that
when
okay?
she says additional report, I don't know what that
She
is.
said initial.
Initial, then I'm fine.
Yes.
Okay, stay fine.
All right. April 5th, 2010.
Yes.
And was that the date of the homicide as well?
Yes, it was.
Okay. Do you recall what time it was that, did you, first of all, respond to the location of the offense?
Yes, I did.
And was that at 842 Brookline Street in Atlanta, Fulton County, Georgia?
Yes, ma'am.
Do you recall the time it was that you responded?
I believe it was a little after 7 in the morning.
Okay. When you responded to the scene, could you tell the court who was on scene?
Detective Griffin was already on scene along with uniform officers.
Okay. What about lay people?
I'm sorry, say that again.
Lay people, people who are not law enforcement.
Yes, one of the roommates, Mr. Davis, was also on scene.
Okay. Were you aware who it was that was the suspected perpetrator of this murder when you arrived on scene?
I wasn't aware of who he was until after I arrived on scene. Once I arrived on scene, I did an initial walkthrough of the scene, and that's when I was told Mr. Lowe was already in the back of a patrol car.
Okay. How long did you stay on scene before leaving?
Maybe about an hour.
And did Mr. Lowe remain in the back of the patrol car during that hour, or had he been taken elsewhere?
He'd been taken to headquarters.
Do you recall who it was that took him to headquarters?
It would have been a uniform officer. I don't recall that.
And was he taken to headquarters at your direction, or do the uniform officers act on their own?
No, he was taken in my direction.
And at that time, was he under arrest?
Yes.
At that time, while he was in the back of the patrol car and when you arrived, did you read him his Miranda rights?
Once we got to the interview room, yes, I did read him his Miranda rights.
So not on scene, he was just
No.
taken to the room.
Correct.
Did anyone, to your knowledge, attempt to interview the defendant while he was on the scene? Anyone with law enforcement?
No.
Okay. And what is that proper procedure to not attempt to interview a homicide suspect on scene?
Correct. It's proper procedure to wait for the detectives.
Okay. And did you obtain information from any of the uniform officers or any other law enforcement officer on scene that they had elicited or received from the defendant any statements whatsoever?
No.
Okay. Where was the defendant taken at headquarters?
To the homicide office's interview rooms, which are located on the 3rd floor of Public Safety Headquarters on Peachtree Street.
All right. And to get to those interview rooms, would you describe how you would have had to, or how he would have had to have been, the area through which he would have been led to get to the room?
10 years ago, he would have come in through the Sally Ports area, which is a fenced-in area at the back of Public Safety Headquarters.
Mhm.
And then he would have been escorted up to an interview room. And then he would have had been leg shackled to the floor and his arms would have been free.
At the time that you were on scene or at the time that you were at headquarters, did you ever threaten the defendant?
No, ma'am.
Did you make him any promises whatsoever?
No, ma'am.
Are you aware whether anybody threatened the defendant?
No, ma'am.
Did anyone promise him anything in order to induce him to speak with you?
No, ma'am.
So when you got to the interview room, tell the court what happened.
I read him his Miranda rights. He immediately requested to speak to an attorney, so no questions were asked of him.
Describe the defendant's demeanor when you observed him in the back of the patrol car on scene.
Calm. Quiet.
And did he comply with instructions that were given to him by law enforcement officers, uniform, detective, or otherwise?
Yes, he complied with everything.
And as you walked into the room, the interview room itself, describe for the court his demeanor there.
His demeanor was still calm and quiet. Introduced myself. And that's when I sat down across the table from him. He was attentive to listening to me.
Was he handcuffed still?
No. He had a leg iron on, but he was not handcuffed.
Okay. Was there any other officer in the room with you during the time that you sat down with him at headquarters?
I don't believe so. But
Now,
I'm not 100% sure.
okay. Are the interview rooms at headquarters equipped with audio, video recording capabilities?
Yes, but in 2010, it was a different system than what we have now.
Okay. Did you intend to record all of your interactions with the defendant at headquarters?
Yes, the recording back in 2010 was a recording that recorded 24/7. There was no way to stop and start a recording like there is now. And so we were under the understanding, it was a brand new facility, that the recording was going, and I hadn't had any issues prior to it not recording. So I was under the understanding that the room was being recorded.
Okay. Do you recall whether you were ever able to retrieve that recording?
No, I was not.
Okay. When you introduced yourself to the defendant, did he say anything that would lead you to believe, or do anything that would lead you to believe that he was in some kind of psychotic state?
No.
Objection, Your Honor. She has no independent knowledge of what a psychotic state is. She is not a medical expert.
You can ask her what she meant in responding to that.
Would you describe on whom or what did the defendant place his attention when you walked in the room? Is he looking at you? Is he looking at
Yes.
the wall?
No, he was looking at me, and he made eye contact with me.
Okay. And did he, during the time that you're talking to him, maintain what you would consider appropriate eye contact?
Yes.
Did he do anything that you would consider unusual in the way of just movements and body language and mannerisms during that time that you're talking to him?
No.
Okay. Was he fully clothed?
At that time, yes.
Did he attempt to take off clothing?
No, not
Did he-
until we asked him to.
Okay. Did he attempt to, and when you say until we asked him to, when was it that you asked him to take off his clothing?
After he requested an attorney, no questions were asked of him. We had crime scene techs come up to the room, and we asked him to go ahead and take his clothes for evidentiary value, and we gave him a jumpsuit.
Okay. Now, where is he placed in order for you to allow him to change into the jumpsuit and give you all the clothing that he had on himself?
He stays in the room.
Okay. And is someone in the room with him while he's doing that?
A male would be in the room with him.
All right. And was there reported to you, or did you have knowledge of any issues with the defendant complying with the instructions to remove his clothing and give them to you all?
Objection,
No.
hearsay.
Okay, in this context, I'll allow that. The answer was no.
No, sir.
Okay.
And after he removed his clothes and was placed into a jumpsuit, where was he taken?
He was then escorted outside to transport for Fulton County Jail.
Did you see him after he had been placed into the jumpsuit?
Yes.
And at that time, did he behave in any way that you would have thought unusual or strange in those circumstances?
No, ma'am.
And did he at any time fail to comply with instructions that you gave to him?
No, ma'am.
Did he at any time respond in an inappropriate manner to an instruction or an inquiry that you made of him?
No, ma'am.
When you sat down with him initially, or in general, when you sit down with suspects, do you obtain biographical information?
Yes.
And is this something that you do in every situation that you have a suspect?
Every interview, even witness or suspect.
Okay. Did you obtain any biographical information from the defendant in this case?
Yes, name, date of birth.
And so when you asked him his name, what did he tell you?
Mr. Lowe, Darrell Lowe.
And the date of birth that you reflected, let me ask you this. Did you place into your file, into your own report, a date of birth
I
for
did.
the defendant?
I did, yes.
And prior to interviewing him at the station, did you know his date of birth?
No, I did not.
Did you ask the defendant his date of birth?
I did, yes.
Did he give you his date of birth?
Yes, he did.
Did you ask the defendant his address where he lived?
Yes, I did.
And did he give that to you?
Yes, he did.
And was that location the same as or different than the location where the murder occurred?
It's the same one.
Okay. Other than name, date of birth, address, what other, if any, biographical information did you obtain from the defendant during your interview at the station?
I did not.
Did not obtain any further information?
No, ma'am.
Okay. After you, or do you read any Miranda rights prior to obtaining the biographical information?
No, ma'am.
So you obtain the biographical information. What then do you do?
I then read him his Miranda rights.
And what rights did you read to the defendant?
That he has the right to remain silent. His Miranda waiver. I usually use a form, the Miranda form,
Mhm.
and I read it to them.
Okay. Do you inform him that he has a right to remain silent?
Yes, and that he has a right to an attorney.
Okay. And do you inform him that he has a right to have that attorney present with him at all times during the interview process?
That's correct, yes.
And do you inform him that if he cannot afford an attorney, that one will be hired for him
That's correct.
or appointed for him?
Yes,
And do you inform the defendant that he does not have to speak with you if he chooses not to?
yes,
Do you inform the defendant that he has the right to have an attorney with him, even during interviews with you, if he so chooses?
yes, I do.
Did you ask the defendant whether or not he understood English?
Yes, I did.
How did he answer?
That he did, yes. He could read and write the English language.
And did you ask him whether or not, or what grade it was that he completed in school?
I believe I did ask him that question, but I don't remember the response.
Okay. Did you inform the defendant that he could remain silent and did not have to make any statement at all?
I did, yes.
Did you inform him that any statement that he makes could be used against him in a court of law?
Yes, I did.
Did you inform him that he has a right to consult with an attorney before making any statements and to have said attorney present with him while he was making the statement?
Yes, I did.
Did you inform him that if he did not have enough money to employ an attorney, that he has a right, of course, to have one appointed and to consult with that attorney before making a statement and to have him present while he is making a statement?
Yes,
Did you inform him that if he requests an attorney, no questions will be asked of him until an attorney is present to represent him?
yes, I did.
And did you tell him that after having, or did you read to him a statement that said, after having my constitutional rights explained to me, I freely and voluntarily waive my right to an attorney. I am willing to make a statement to the officers. I can or cannot read and write the English language and fully understand my constitutional rights to an attorney. I have read or have had read to me this waiver of counsel and fully understand it. No threats or promises have been made to me to induce me to sign this waiver. Did
Yes.
you read all of that to him?
Yes,
And did you circle the can in the sentence, I can and can't write and read the English language and fully understand my constitutional rights to an attorney?
yes, I did.
Okay. And did you circle the I have had read to me this waiver of counsel and fully understand it?
Yes, I did.
So did you read the entire Atlanta Police Department waiver of counsel by defendant in custody form to the defendant during the
Yeah.
course of your interview?
Yes, I did.
Okay. As you were reading this form to the defendant, would you describe to the court his behavior? What he did?
Well, when I read a form and when I go through each line, I ask them if they understand. So like the first line, it says, you have the right to remain silent. I'll then ask, do you understand this? And I ask them to verbalize yes or no. He would verbalize to me, yes, that he understood them.
I am going to show you, Ms. Shubo. Okay. Yes. I'm going to show you what will be marked in paper form as State's Exhibit 1. And I'm going to ask you if you recognize it. Your Honor, may I have screen sharing capabilities?
Yeah, do you not?
I don't know, but I'm going to try.
To try.
Okay.
Verbally, I say yes. Technically, you should have it.
All right. I have it. Thank you, Judge.
Excellent.
All right. I'm going to show you State's Exhibit 1 and ask you if you recognize the document shown in State's Exhibit 1.
Yes, I do.
How do you recognize it?
Well, one, this is my handwriting, and two, this is the Miranda waiver that I read to Mr. Lowe.
Okay. And I'm going to scroll down so that you see the entirety of it. And do that without going too fast here. Is that your name or initials over the line officer detective's name?
Yes, it is.
All right. And have you seen the entire form on the screen? Have you been able to look at it?
Yes, I have.
Is this a fair and accurate copy of the Atlanta Police Department waiver of counsel by defendant in custody form that you read to the defendant Darrell Lowe on April 5th, 2010?
Yes, it is.
Is there any material alteration? Anything
No.
different about it?
No, ma'am.
Your Honor, the state tender states Exhibit 1 is evidence. I will give to the court a paper copy of it.
Sure. Any objection to states one?
No objection for the purpose of this hearing.
Admitted.
Detective Benton, over on the far left side of the screen, to the left of the numbers 2 and 3, would you please state for the record what it is that is noted?
It says 9th grade.
And would you tell the court what that is?
That's the grade he stated he had completed.
Okay. So you did ask him what grade he had gone to in school, and he answered you. Is that
Yes,
accurate?
he answered. Yes, he answered 9th grade.
Okay. Now, after you finished reading all of this, and by all of this, let me be clear. The paragraph in this form that reads all of the above constitutional rights and the above waiver of counsel were read to the above defendant by me, and she freely and voluntarily waived his or her right to an attorney, no threats or promises. Did you read the entire form to him?
I did not read that paragraph to him, no.
Okay. Why not?
He refused to speak to us without an attorney present. So that right there states that he would speak to us freely and voluntarily, which he did not.
All right. And how did he refuse? At what point did he inform you that he did not want to talk to you?
After I do have any threats or promises been made to induce you to sign this waiver, and he stated no, I then asked him if he was willing to speak to me without an attorney, and he said no, he wanted an attorney.
Okay. Now, once he tells you that he wants an attorney, do you attempt to further interview him?
No.
So what do you do?
At that point, I left the room and contacted crime scene. And that's when once crime scene arrived, we took possession of his clothing and gave him a jumpsuit and requested transport.
When you get up to leave, do you make any statements to him such as, this is your final opportunity, or anything else that could be construed as an attempt to induce him to say something else?
No.
When you get up to leave, what, if anything, does the defendant, before that, do you tell the defendant what you're about to do as you get up to leave? Or do you just walk out? How does that work?
No, when I go into the room, we ask him to turn around so we can place him back in handcuffs. Once he's back in handcuffs, we take off his leg shackle so he can walk. And then I'm letting him know as we're escorting him out that we're taking him to his transport, because he'll be transported to the Fulton County Jail.
Okay. Now, have you and I spoken about this case prior to today?
Yes.
All right. And did you and I speak about this case as far back as January or February of this year?
Yes.
Okay. And at the time that we spoke back in January or February of this year, did you recall any statements that the defendant had made to you?
I don't
At that
remember. I don't think so. I think because it had been so long, I had to review the file first.
Okay. And at some point, did I provide to you a copy of a reproduced copy of a transcript of the preliminary hearing in which you testified regarding the defendant in this homicide?
Yes,
And did you have a chance to read over all of the preliminary hearing transcript that I gave to you?
yes, I did.
Do you recall the date of that preliminary hearing?
I do not.
Do you recall whether it took place in 2010?
It did take place in 2010.
Okay. And at the time that you testified at that hearing, were you under oath?
Yes, I was.
And you were questioned by both the prosecution and the defense, correct?
That's correct.
Right. Did you speak at the preliminary hearing, or once you reviewed the transcript, did you recall, or was your memory refreshed as to any statements or comments that the defendant may have made during your interactions with him?
Yes.
Okay. And what statements were those that your memory was refreshed after you read the transcript?
That he had been arrested for armed robbery, ag assaults, murder, and kidnapping in the past, and he had gotten away with it, and he will get away with this one too.
Do you recall whether that statement was something that you had informed the prosecuting attorney about prior to the preliminary hearing?
Yes, it was.
Okay. Now, that prosecuting attorney was not Adrian Love, correct?
No, it was Jack Bars.
All right. Did you testify and tell the court that the defendant had refused to talk to you and had asked for an attorney?
Yes.
Okay. At what point did you tell the court about that statement that the defendant made to you as you were getting up to leave?
It was actually as we were walking to the patrol vehicle. We had already left the interview room, I believe, is when it was said.
Okay. Did you offer up that statement, that testimony on your own, or was it where you asked a question that caused you to, in other words, were you asked by Mr. Bars if the defendant made any statements to you at all?
I was asked.
Okay. And at that point, is that when you told him about these statements that the defendant made as you were leaving?
That's correct.
Okay. Now, do you recall, you said just a second ago, I believe that it was as I was getting up or as I was walking to the car. Do you or do you not recall exactly where it was or when it was that he said that?
No, it was as we were walking to the patrol car.
Okay. And if in the preliminary hearing, you said, as I was getting up to leave, he stated that he had been acquitted of armed robbery, aggravated assault, and murder and kidnapping, and he'd get away with this too.
That's getting up to leave to go to the patrol car.
Okay. And at that point, did you, prior to him saying that, did you say anything to him that spurred that comment?
No,
Right.
other than we're headed to Fulton, you're going to Fulton County Jail. You've been
Okay.
charged with murder.
Okay. So at that point, you had informed him, or you had just informed him
That he was being
that
transported.
that he was being transported to jail because he was being charged with murder?
Yes, ma'am.
All right. At any point prior to then, do you recall if you told him that he was being charged with murder, or was that the first time?
I believe that was the first time.
Okay. And would you describe for the court the way in which the defendant made those statements to you?
Very nonchalantly.
Okay. Do you recall whether he used your exact words, he had been acquitted of these things, or did he say it in his own way and what you testified about was the gist of what he said? Did he say it this exactly or what?
No, it was in his own way that he had gotten away with it. I don't believe he used the word acquitted. He had
Okay.
just basically stated he had gotten away with it previously.
All right. Before you went in to speak with the defendant, and after you left the crime scene, how much time did you spend researching the defendant?
I didn't.
And do you all, as part of your initial or preliminary investigations in the first stages of an investigation, when you have a suspect, what do you do to prepare for the interview?
It depends. You may do some background information. It depends on the case in general. This particular case, an officer saw the defendant. I mean, I'm testifying to what an officer saw here. So it just, saw the defendant with the knife in his hand in the bathroom with the deceased victim. So I didn't, and I knew that they lived in the same house together. And
Right.
I'd spoken to a previous roommate. So that was enough of a background for me to go into an interview room with him.
Okay.
It wasn't until after he had left for Fulton County that I pulled his criminal history.
Would anyone else have told you, or did anyone else? Let me ask that in a better way. When did you first learn that the defendant had been acquitted of armed robbery, aggravated assault, and murder and kidnapping in the past, and had gotten away with those things in the past?
When he told me.
Okay.
Your Honor, that's not an accurate statement. And so when did she learn of that? It's wrong.
So that would be something to examine the witness on. You may want to try to, I don't know if impeach is the right term, but you can bring that out rather than saying you think it's wrong.
Thank you.
Okay.
Thank you, Judge. And Detective Benton, at the time of the preliminary hearing, how much information had you pulled or researched on your own about any of the previous offenses the defendant may or may not have committed?
Only his
Beyond-
criminal history. We don't have access to other jurisdictions' actual files and reports unless they request them. And I did not request files from previous arrests. So only looking at his criminal history and what the conclusions of those were.
Okay. And even now, do you know the specifics of the dispositions in the defendant's previous cases that he may have had? Do you know, like, whether or not he was ever adjudicated guilty or insane or incompetent? Do you know anything about those things?
The insane incompetency, I do not know. I do know that it was downgraded to, I believe, involuntary manslaughter, and he served a few years.
Okay.
You say you know that now. Was that something you knew, Detective, on April 5th when you and Mr. Lowe were together?
No, I did not know that on April 5th. I didn't pull any of his criminal history until after he had been transported to the Fulton County Jail and been charged with murder.
Okay.
And when the defendant relayed this information to you about his past offenses, was it intelligible? Could you understand what he was saying?
Yes.
Or did you have to like extrapolate and guess?
No, I didn't say anything at that point. I was, to be honest with you, I was a little stunned
Why were you a little stunned?
that he had said that and admitted it. I hadn't had that before.
And was that entirely unsolicited?
Yes, it was.
And as he was saying it, you indicated he appeared nonchalant?
Nonchalant, calm, voice was not raised.
Did he appear to be hallucinating, seeing any hallucinations, hearing any voices? Did he act like he was undergoing any of those things?
No.
Did he appear in any way unable to control his own actions and movements?
No, like I said, he was complicit in anything that we asked of him. When we asked him to sit down, he would sit. We put the leg irons on him. When we asked him to stand up, to turn around, he did. We put the handcuffs on him. Even when we asked him to change his clothes, he did. So he was complicit, and we were asking questions like that.
So is it fair to say that he was cooperative with you?
Yes.
But when you asked him to speak with you, or if he wanted to speak with you, he said no.
That's correct.
So was he able to tell you what he wanted you to know and tell you what he didn't want you to know or didn't want to do?
Yeah, he basically stated he did not want to speak to us.
Did the defendant do anything at all to, did you know at that time rather, or did he give you any reason to believe that he had any kind of psychiatric diagnosis?
No.
Did you ever learn that he had some psychiatric diagnosis?
Not till recently, to be honest with you. I didn't even know this case was still going.
Okay. And have you had occasion during your 22 years as a law enforcement officer to come in contact with people who are having, in lay words, episodes, mental health episodes?
Yes, actually, I'm a negotiator, hostage negotiator. So I'm dealing with the mental health on a regular basis when I'm getting called out to emotionally distressed individuals.
Okay.
And having to calm them down. And I've dealt with people going through schizophrenic episodes, bipolar, manic depressive.
Have you dealt with people who appear to be acting under like a delusional compulsion, like, or
Quite
hallucinating, seeing things?
Quite often, yes.
And have you dealt with people who have done things but don't appear to appreciate the gravity of what they've done? In other words, they might have, stab someone, but act as if, nothing happened. Or
Yes.
it was it was somebody from space that made him do it.
Yes.
And did the defendant exhibit any of these kind of actions or behaviors during your interaction with him? Any of the ones that you've previously seen during your 22 years as a law enforcement officer, when interacting with people that you knew had mental health challenges?
No, ma'am.
Thank you, Detective Benton. Just one second. That's all that I have for now. And Ms. Shubo, if you need my computer, tell me if you need me to do something. That's all that I have for now. Thank you.
All right, Ms. Shubo, cross-examination.
Yeah, can you unscreen share?
Yep.
Detective Benton, do you have your report in front of you?
You do?
I do not.
You do not. Okay.
I apologize. I was unaware of a court proceeding this morning, so.
I understand. I understand.
We appreciate you making time for us from the box room.
You got it? She's got it. Good deal. Okay.
I'll tell you when to screen share.
You're already screen sharing.
Yeah, I'm
Okay.
gonna ask questions, and then if we need to screen share, we'll do that if that's all right with.
Oh,
everyone.
absolutely.
Okay. Okay, so I wanted to start with the beginning. What did Mr. Lowe look like at the scene?
I know he had blood all over his clothes. But like I said, he was in the back of the patrol car when I glanced at him and asked him to go ahead and be sent to public safety headquarters.
Okay, and then he got out of the patrol car and was taken to the room. Is that correct?
Yes, but I was not there when he was taken out of the patrol car and taken to the room.
Okay, and you saw him when he was in the room. Is that correct?
Yes, ma'am. Yes,
Okay.
ma'am.
And did he still have blood all over him?
Yes, that's why we collected his clothing.
Did he have blood on his face?
Oh, I don't recall that.
Do you recall if he had it on his hands?
No, I'd have to go back and look at the photos that the crime scene techs took.
Okay. When you spoke to him, did you make eye contact with him?
Yes.
Did his eyes do anything strange? Or was he making eye contact? Was he looking off to one side or another?
Sometimes he'd make eye contact, sometimes he wouldn't.
Okay.
Is that particularly different from any other suspect you've interacted with?
No, no, sir.
You said he was compliant. Do you remember the tenor or speed of his voice?
The
Was it-
speed?
Yes. Was he speaking quickly? Was he speaking slowly? Was he going up
Normal?
and down in his voice? It was normal. Okay.
It seemed normal to me.
Okay. I want to now share your police report. When you write a police report, you try to write down everything that's important. Is that correct?
We try to be detailed, yes.
With me, you don't need to you don't need to ask all those questions. With a jury, feel free to do it. But I bet she tried to write the best report she did. And if there's something that's not in there, boy, that's peculiar.
Okay.
So dive right on in.
All right.
Thank you.
In the entirety of your police report, which we are going to share with you page by page, did you ever write about this statement that you spoke about in the preliminary hearing allegedly?
I don't believe so, no.
Okay. You stated that you were stunned by the statement. Is that correct?
I was a little stunned, yes.
Okay. And you said that this was kind of very irregular for someone to state something like that. Is that correct?
I would still consider it to be irregular, yes.
And that would be something that you would want to write in your report if it was stunning and irregular.
No, because that would be an opinion.
Okay. Would statements of the defendant be something that you would want to write in your report?
Normally, yes.
Normally, yes. And so, but you didn't in this report. Is that correct? Or do you need to see it to?
If it's not in the report, then no, I did not.
Okay.
You're not, if Ms. Shubo represents that the statement's not in there, you're not challenging that. You don't have a specific recollection that it's in there.
No, I do not.
Okay. I don't think we need.
I trust the attorney.
Okay, and I'm confident Ms. Love will point us to it if it is in there. So you don't need to go page by page to say, do you see it here? She's saying it's not there. Well, she's agreeing with you that it's not there.
All right.
And I'm finding that it's not there. Okay.
I want to talk about this happening 12 years ago and the kind of history of you coming to remember this statement. When were you first contacted by Ms. Love about this case? Again, recently in the past year.
Maybe January.
Maybe January. And when you spoke to her in January, did she state that she received a motion from the defense?
No.
Did she state that there was this statement that she was wondering about?
The way that the conversation occurred when she called, she asked if I remembered a statement that Mr. Lowe had given to me. And I was like, I have absolutely no idea what case you're talking about, because it had been 12 years. And of course, I've been in homicide 13. So I was like, oh gosh, I have no idea. So she had to remind me of what case. And that's when I was like, had no idea this case was even still.
So after your first conversation, did you pull your police report?
No.
So at any point until Ms. Love shared with you the preliminary hearing transcript, did you review anything to remind yourself of the case?
No.
So so you had a conversation with Ms. Love. She asked about the statement. You said you have no memory of that because it was 12 years ago.
No, I said I had no. That's not what I said.
Please correct me.
What I said was I don't remember what case she was speaking of, because we were also talking on the same conversation about another case.
Okay.
That was 10 years old. That defendant, we had court on that yesterday. So she was telling me that we had a couple of cases coming up, and she was asking me about specific cases, but I didn't have any previous interaction to review something before she asked me a question. So I didn't know which case she was talking about. I didn't have any recollection of what case we were talking about. She would normally call by the defendant's name, and I would have to say, who's the victim? Because we go by the victim's names. And that's when she stated what the case was. And that's when I was like, oh yes, now I remember.
Okay. And when she stated it and you said, oh, I remember, did you then remember the stunning statement?
Yes.
Okay. So when she talked about it, was that before or after you got the preliminary hearing transcript?
I didn't get the preliminary hearing transcripts until 10 minutes prior to this call.
Okay. So if you hadn't have had the preliminary hearing transcript and we had had this hearing a half an hour before the call, so you wouldn't have had it, would you have remembered that statement?
Yes.
Okay. And did you ever tell Miss Lowe that? Miss Love that?
Yes.
Okay. Excuse me 1 minute.
Mhm.
Okay. I want to ask you about the recording that didn't happen. Is your testimony that the recording happened and was subsequently lost, or is your testimony that you thought it was being recorded, but it wasn't?
No, my testimony, well, okay, so back in 2010, we had a system that was recording 24/7. And what we didn't know, because it was brand new and the building was basically brand new, is that the server was crashing often. And this was one of the cases where we learned that the server was crashing. And that's when we started backing up our interviews with digital recorders. So when I went to go to the system to pull this interview, that's when we learned that the server had crashed and it was actually not recording.
Were there any other statements given by Mr. Lowe throughout your entire interaction with him?
Not that I recall, no ma'am.
So the biographical information, the I don't want to talk to you, Miranda, and then this statement that happened on the way out of the room. Those are
Yes,
the three.
ma'am.
Okay.
Yes, ma'am.
All right. I want to talk about the researching the defendant. So when you were talking to him, you had not researched the defendant's criminal history. Is that correct?
That's correct.
Okay. Did you research his criminal history between the arrest, after the arrest, before the preliminary hearing?
Yes.
Okay. So you were aware when you testified as to at least what was on the GCIC about his criminal history.
That's correct.
Okay. And were you then, at that point, did it connect in your head as to what he said based on what the criminal history was?
That's not when it connected. What made me go and look at his criminal history was because of his statement. And I was like, because I didn't know if it meant he had killed somebody and never got caught, or if he had killed somebody and got acquitted. I didn't know what that statement meant. So I was actually going back, look at his criminal history, one, to see if he'd ever actually been arrested for murder before. And so after he got sent to Fulton County, that's what made me go and look at his criminal history.
You stated that
the reason I had pulled the criminal history, if it wasn't on there that he had been arrested for murder in the past, my assumption was if that had not occurred, there's a body out there somewhere.
Gotcha. When he made this statement that we're talking about, did he sound angry?
No.
When you talk about being nonchalant, was it just basically like, hey, just wanted to give you information that I've gotten away with this before? Or can you describe it in a little more detail?
No, it's just as we were walking, he just made the statement.
Okay. Did that strike you as something that would be indicative of mental illness?
No.
Do people often spontaneously confess and or talk about a previous murder that they've had?
I haven't, well, I've had a few talk about previous murders, and I've had a few say that it was their fault, even though they didn't technically commit the murder.
No further questions.
Any redirect, Ms. Love?
Yes, thank you, Judge. Detective Benton, how many cases have you investigated in the 12 years since this murder happened?
Oh gosh, over 100,
Okay.
not including the 53 behind me.
All right. And you were asked on cross-examination. I'll start with the last question about this sort of statement or utterance being indicative of mental illness. Did the defendant appear, concerned that he was going to now be held accountable for murder?
No.
Did he offer up any reason, such as, they're going to find me insane? Did he offer up any reason why he was going to get away with it again, if you will?
No.
Was the preliminary hearing in this case done, backing up to your normal procedure when you are preparing an investigative summary to give to the DA's office as part of your case file? Do you write that up like on the same day of the homicide when you respond to the scene? Do you write up your investigative summary?
No.
Typically, our preliminary hearings held prior to the completion of your investigative summary.
Yes.
And in this case, was the preliminary hearing done before your report was ever written?
Yes.
Okay. Now, you were asked about the recording in your report and what's not in your report. Is one of the uses of recorded statements that you get to review the statements or review the recordings and then put that information in summary form in your report?
Yes.
And did you have anything like that in this particular case to refresh your memory about what happened or what didn't happen?
No.
Okay. At the time that you made your report?
No, ma'am.
And so the preliminary hearing is done shortly after the homicide occurs?
I believe within a week and a half, yes.
And the information that you are able to talk about during the preliminary hearing, is it still fresh on your mind?
Yes.
From when it occurred?
Yes.
In order to complete your investigative summary, to the point that you want to give it to the DA's office as in your case file, do you do further investigations? Do you do other stuff?
Yes.
Does time pass between the time that you testified at the preliminary hearing and the time that you complete your investigative summary and hand the case file over to the DA's office?
Yes.
Are you able to concentrate on just this one homicide, or are you still in the rotation?
No, I'm still in the rotation, catching other cases and also helping out on other cases that are not mine.
And between the time of the preliminary hearing in this case and the time that you finished your report and submitted the case file to the DA's office, do you know how many murder cases you were working on?
5 or 6.
And in what stages were these cases? Were they, were you just doing light stuff on them, or were you actively working these murders?
No, I was actively working them.
When you testify at a preliminary hearing under oath, and then about things that you remember, do you always put in your report the things that you remember or talk about at the preliminary hearing?
No.
Do you go back to headquarters and type up what you just said at the preliminary hearing?
No.
You were asked when it was that you spoke with me on cross-examination, and when it was that you received the transcript. Do you recall that?
Yes.
And you said you had gotten it about 10 minutes before this hearing started. Do you remember that?
Yeah, maybe 30 minutes.
Okay. Are you able to pull up? How did you get it? Did you get an email or a hard copy?
Email.
Are you able to pull up the email that you got
Yes,
from me? Would you pull it up, please?
I have it up.
Oh, okay. We can't see your phone, but thank you. All right. Now, is that email an original email or a forward of an email?
Well, hold on, going back. It's a forward.
All right. And what is it a forward of?
I don't know. It doesn't tell me. It just says forward of preliminary hearing transcript.
Okay. All right. I don't know if you're able to access older emails, but I'll just ask, do you recall being sent a copy of the preliminary hearing by me of transcript in the form of a PDF titled Recreation of Prelim Transcript .Daryl Lowe
Yes.
.PDF?
I can see it now.
You can see it now?
Yeah.
What date did you get the original?
March 31st, 2022.
Perfect. And after that, are you able to see the correspondence between, first of all, what does the email say? Can you read it?
Please take a look at this and tell me if it rings any bells.
Okay. Do you recall what your response to me was, or if you responded to me on March 31st?
I believe I didn't read it. I didn't read the transcript. I just remember the name from our conversation in January, and I sent back yes.
I remember you said, I remember the case. What do you need?
Yes.
Okay. And do you remember, or can you pull up my response, what I asked you in response to?
I
Okay.
don't have your response.
If I were to show you that email, would it refresh your recollection?
Probably yes.
Okay. Hang on one second. I want to show.
Okay.
Shoot. So let me back up and show you. So this is the initial email. Actually, it had yes. That's what she said. And then she said, and then this is what I sent back to me. All that.
And what was her response to that?
She didn't write back. I don't even know if she read it.
But she didn't write back.
No. Okay. I'm trying to make sure. Okay. I'm going to show you a copy of the email. I'm going to share the screen and see if it refreshes your memory. Okay. I'm going to go down.
Okay.
Are you able to see the screen?
Yes.
And on the screen, are we looking at the forwarded sort of an email chain beginning March 31st, 2022
Yes.
at 12:08 p.m. Okay. And that's from me to you.
Mm-hmm.
And you respond, I remember this case. What do you need? Correct?
Yes.
And my response to you, could you look at it and tell me if you remember reading it, never saw it, what, or what?
I remember receiving it,
Mm-hmm.
but I'm not sure if I actually read the email.
Okay. And what was it that I asked you?
if I remembered the testimony from page 6, lines 3 through 8.
Okay. And as far as you know, after reading the transcript, did I post into the email the language from the transcript when I asked if you remembered this testimony?
Yes, when I read the transcript this morning, this is the language from the transcript that I read this morning, yes.
Okay. And at that time, did you send anything in response to that last bit of language that you see on the screen now?
I don't think I did, no.
Okay. All right. You were asked about the cadence, the defendant's cadence during the conversation. You were asked about the speed of his voice.
Mhm.
So Detective Benton, when you're answering, if you could say yes or no, or whatever your
yes.
answer is. The court
Sorry.
reporter's not good with,
Sorry.
thanks.
All right. When you said the speed of his voice seemed normal to me, had you ever spoken with the defendant before?
No, ma'am.
During the course of your and my conversations, is there one of us that tends to speak a little bit quicker than the other?
Sometimes you talk really fast.
Me?
Sometimes when you're talking to other people and trying to talk to me at the same time.
Okay. And so when you're saying that the speed of his voice seemed normal, how would you describe a voice speed that was abnormal to you?
A speed talker.
And by speed,
One of those people at the end of a commercial they've sped up their voice.
When they do the warranty and the exclusions.
and have you talked to people who seem to just be talking out of their head, saying stuff so fast you can't understand what they're saying?
Yes.
Okay. And
It sounds like that's more like Ms. Love than Mr. Lowe. Is that a fair?
Please don't answer yes to that on the record. Please don't. And was the defendant's voice, did his voice at any time sort of fall into that category?
No, ma'am.
Now, have you also talked to people who talk so slowly that they appear to be sort of under the influence of something?
Drunk people, yes.
Yeah. And was the defendant's cadence so slow that he appeared to, like something was wrong?
No, ma'am.
Okay. When you said that you looked back to see if the defendant was arrested for murder, were you set to go and start looking for another body or start trying to work on another case if you needed to?
Yes.
Okay. All right. Just 1 second. Your Honor, I would like to speak with Ms. Shugo. I want to show her a document that I need to ask about.
Okay.
Monday, Friday or something. And he got
I've definitely seen pictures. I think I've seen this, but I can't tell you 100% without looking through everything. But I have no issues with whatever you're doing with this. That's not a problem.
I'm going to show you what I will mark as State's Exhibit. Yeah, join this on 2. You were asked by the defense whether the defendant had blood on his clothes or face or hands. And so I'm going to.
I would concede he had blood all over him if that's what the issue is. It's fine if you want to do it, but all I'm saying is that was not my point. We don't have proof of that, so if you want to do this, you're welcome to. But
Okay.
Totally.
Well, then do you have a problem with just putting just
The pictures? No.
Yeah, okay. All right. So, Your Honor, the state tenders State's Exhibit 2, which is a series of photographs of.
You're tendering it because there's no objection. There hadn't been any foundation laid, but if there's no objection from the defense, it can come on in.
That is exactly what we just talked about. And I'll let Ms. Shubo speak to that. And I won't speak for
no
her.
objection for the purposes of this hearing.
Sure. And to be clear, everything that we're working through today is introduced for the purposes of this hearing. Whether, for example, the Miranda waiver comes in at trial, separate evidentiary basis. Same with these photos.
Of course.
So
No objection.
no objection to States 2, which is a collection of how many photos?
It is, go to the folder, a collection of 15 photographs.
Okay. They are admitted.
Thank you. Detective Benton, can you see the photographs in State's Exhibit 2?
Yes,
And do these accurately reflect what the defendant looked like at the time that you all took pictures of him? Are these the pictures that you took before you took his clothes off his body?
yes.
Right. You can stop sharing. And finally, would your testimony at a preliminary hearing be a fair supplement to any written report that you composed at the end of your investigation?
Yes.
Thank you. That's all that I have.
Any recross?
3 questions.
All right. I'm going to hold you to that. Because again, we're focused on whether the statement was voluntary or not.
I'm
And
asking.
okay, not the potential credibility later on.
Yes. My question is, I heard for the first time that you had the preliminary hearing and then you wrote the report. Is that correct?
That's correct.
Okay. So even though you
That was
had.
one.
I got you. Even though you had the preliminary hearing, it seemed to be an important issue with regard to the statement. You still didn't put it in your report. Is that correct?
That's correct.
Okay. 2. I only used 2.
Great. You've got one in reserve. All right. May Detective Benton be excused to return to the boxes.
Yes, Judge, and thank you.
All right.
Judge.
Thank you, Detective. We'll see you some other time.
Thank you, sir.
Any other evidence you want to present, Ms. Love?
No, Your Honor. The 2 exhibits, the ones that we referenced earlier, are the only exhibits, and we have no other witnesses, just argument.
Okay. Ms. Shubo, any evidence you want to present?
No, Your Honor.
All right. Then we'll say that the record is closed other than argumentation in this question about whether Mr. Lowe's statement ought to be suppressed at trial. I'm happy to hear argument now. As you're thinking about what you're going to argue, I'll let you know that I think, and I'll enter an order and I'll cement my findings after I do more research. Some of what has been highlighted here would go to the weight the jury ought to give the statement. If it's allowed in, why wasn't it in the report? So much time has passed. How accurate is the word for word recollection? That's not anything I need to decide right now. So I would spend less time talking about that and more time on what the indicia are that I ought to consider in connection with the, I guess we say voluntariness. I will tell you now, I find from the record that's been made, Mr. Lowe was advised of his rights and he invoked them. I don't think there's a dispute about that. He said, either I want a lawyer or I don't want to talk, or both. And the record's pretty clear, I think, that Detective Benton honored that request. Okay, we're done. They went through some procedure after that involving getting out of the clothes that are shown in the 15 photos in State's Exhibit 2 and into a jumpsuit. And then they were en route. Detective Benton, Mr. Lowe, and I assume one or more other officers were en route from the interview room to a patrol car so that Mr. Lowe could be taken to the jail. And somewhere in that journey, Mr. Lowe said what he said. And so voluntariness may be the analysis we need to work through, but it's not the classic voluntariness of, well, wait, did he understand his rights? Was he induced to waive his rights? Because he didn't do any of that. He said something spontaneously. But I think what I'll hear from Ms. Shubo when it's her turn to argue is that, assuming it was said, yes, it was spontaneous, but it wasn't voluntary because of the situation that Mr. Lowe continues to find himself in. I share all that just so that you don't cover things that I'm already agreeing with you on, or that I don't think are issues. But if you think they are issues, we can put them back on the table. And lastly, I don't think we need to spend a lot on, was it recorded or not? It wasn't. It was meant to be recorded. In fact, everything ought to have been recorded, but the server crashed. And so nothing was. It wasn't that a detective forgot to press the on button or intentionally didn't press the on button. It was an always on situation that at that point was never on. All right, with that, tell me, Ms. Shubo, as the movant, why it is that I ought to suppress this statement from your client. And I'm going to put Mr. Lowe big on the screen again.
Thank you.
And after we're done with this, we'll do a status check with him before we turn to the next motion.
Thank you.
All right, there he is.
Your Honor, we provided before the hearing, and I'm sure you have it at some point, the cases that we're referring to: State versus Gardner, 254, Georgia, 264.
So I wrote down Gardner, Hitson, Mincy, Fife. Those may not have been all your cases. I didn't write down who wanted me to look at those cases.
Yes. So I sent a follow-up email, which had the cases which are some of those cases. So definitely Gardner, Hendricks, Mincy versus Arizona.
Yep.
Blackburn versus Alabama, which is the U.S. Supreme Court case, 361 U.S. 199.
Hold on. Let me get that, because your email may be somewhere more accessible. Was the motion that we must have talked about informally, because I wrote in red some of these cases that I was glancing at just now. So let me just get to the argument. My notes. All right, so
Gardner.
I got Gardner.
Okay. Blackburn versus Alabama is 361 U.S. 199, and it's a 1960 case.
Okay.
And then I did share with you Fife versus State, which is contrary authority to my argument.
Well, that's why I was not sure who shared it, because I started with Fife. I'm like, that's not a great case for the defense.
Yes.
But that's you being thorough.
Yes.
All right.
Trying to be.
Okay.
So the court is well aware that almost immediately after this, up until on and off, up for 12 years, Mr. Lowe was incompetent to stand trial. I fully acknowledge that the witness that we just had is stating that he appeared outwardly to be sane, or at least mostly there, if not completely there, based on her lay view of him. However, it's kind of a chicken egg situation with regard to the defense in this case, because if he was insane, which is something the jury is going to find or not find, then his statement shouldn't have come in because he was insane, and we're going in circles here. And so to use that against him while that is our argument, we feel is inappropriate, especially given Gardner, where it states specifically a confession made by one who is insane is not the product of rational intellect and a free will. And then the Supreme Court cases that we're talking about. So I definitely think that, if our argument, we have evidence to support our argument that he was insane at the time, and that if he was insane, then this statement would be involuntary, would be best practices of the court, in my mind, to not allow that statement in, so we don't have the issue at the end that he actually was insane.
Do you agree that you could in some ways use the statement in support of your argument that Mr. Lowe was not sane at the time, not only of the killing, because these are separated by several hours, but
Correct.
I don't know how quickly people would phase in and out of that, but at the time he supposedly made this statement. I mean, the content of the statement, it's sort of, I think the point you were trying to make through the detective is that something that someone in his right mind would say surrounded by law enforcement?
Correct. I think that there would be a strategic decision that Ms. Primovic and I would have to make about that, but I don't think that goes to whether the state can introduce it.
No, I understand.
Yeah.
I just am trying to, the prejudice of it coming in is mixed because it's something that is not inconsistent with the defense you plan to bring.
I think that that is partially true, but I also think it is very prejudicial, depending if the state's argument, especially with the 404Bs, that.
I don't disagree. It cuts in both directions. And I can think of ways that Ms. Love could argue powerfully to the jury. It shows he's always scheming and this is a front. And how you could equally powerfully argue, of course he's saying things like that, because look what's been the situation for the last 12 years. So, okay.
I mean, I'm not going to disagree with you that it would be a conversation that me and Ms. Primovic would have. I think that is a strategy conversation that we should have. And
it's not a legal question.
Not
You're
a
right.
legal question.
Okay. So what you say the case law stands for, Gardner, Blackburn, is look, if I make the finding that Mr. Lowe was insane at the time, it's not voluntary. It can't come in.
Yes.
If I find that it's something other than he was insane at the time, then I may need to weigh some of the typical 7 factors, although those are usually applied to I waived my rights, but I was only 16, I didn't understand them, or I've been drinking, or things that might call into question an officer's assertion like, no, he understood and he waived his rights. We don't have that here. It's a different.
I think it's a one issue part of the Jackson Deno goes strictly to if he was insane, could anything he said be considered voluntary?
Yep. Got it.
And I
Okay.
don't need to continue because I think we're all on the same page of the argument.
All right. So Ms. Love, I'd like to hear your view on this. I think the law says what Ms. Shubo says, and Fife, I don't think contradicts that. Fife says the fact that someone is at some point deemed to be incompetent to stand trial doesn't mean. Fife was about understanding the rights that were waived. It was I think he was a 17-year-old guy, and the officers didn't have maybe all the information that parents had. But the Court of Appeals said they're not coterminous. A expert saying Fife is not competent to stand trial doesn't draw a line such that anything Fife might have said to law enforcement is excludable as being involuntary. And Fife was focused on the waiver as opposed to what was said after that. But it's an important principle, and I think it's where we would be if I don't find that, well, the burden is actually on you. If I find that you've shown by a preponderance, it's not a high burden, that Mr. Lowe was not insane at the time, then I think we're in Fife land, and it may well come in what Mr. Lowe said to Detective Benton and those around him. So I share that with you just because I did read some of the cases in preparation for now, so you don't have to repeat that part. But tell me what you want to about the state's perspective.
Thank you, Your Honor. So with respect to being insane at the time of the act, the court is well aware that the defendant has to meet one of two criteria. And Ms. Shubos, the defendant's contention is that he was legally insane, and therefore the statements that he made were not voluntary because he was legally insane. The state has presented the testimony of Detective Benton, who talked about the fact that the defendant's words to his roommates, and the state expects that the evidence will show at trial, were that the reason the defendant stabbed Mr. Giddens is that he believed he owed him money. And the defendant was upset by that, and so he stabbed him. There is nothing, we believe there is not any evidence that suggests the defendant was overcome with some delusional compulsion that overmastered his will to resist committing the act. In fact, I expect that the testimony will show that when the police arrived, the defendant dutifully stopped committing the act. The fact that he is more compliant when a law enforcement officer comes on scene, and the fact that he is able to appreciate that he needs to stop doing the act, flies in the face of an assertion that, one, he can't resist doing the act because he stopped when that police officer said stop, and two, that he didn't know it was wrong or he didn't know the difference between right and wrong. Because again, he stopped doing the act that was wrong when law enforcement arrived on the scene. Coupled with Detective Benton's testimony about the defendant's, the way that he appeared, his demeanor, his behavior, his actions, his own words, there is literally nothing to suggest that the defendant was unable to appreciate right and wrong, or that he was unable to resist doing what he did. The fact that he had or appreciated that he should ask for an attorney, while not something that necessarily that we can say, to a jury, we can't say, he asked for an attorney. It's something that reflects his state of mind, his presence of mind, and his sanity at the time that this act was committed. I believe that, which case is this? Which case is this? The case that you had up. that the cases that Ms. Shubo cites are distinguishable. Blackburn is distinguishable. In Blackburn, there were doctors that said, that opined that the defendant was insane at the time that he committed these acts. In this case, there are doctors, and I understand that that's the subject of the next part of the hearing, that have opined
The opposite.
the opposite. And the evidence, the defendant is presumed sane. Ms. Shubo has the burden of showing by a preponderance of the evidence that he is or was insane at the time of the act. And there has been literally no evidence to suggest that he was insane at the time of the act. Her words to the court were that he was at least mostly there. Detective Benton testified there was literally nothing that gave her any indication that he even had a mental illness or a mental health diagnosis. Even the argument or the contention that the defendant's nonchalant statement that he's gotten away with it once, he'll get away with it again, I'd argue is more reflective of arrogance because of his awareness and appreciation of his mental illness and the leeway that it gives him in terms of criminal responsibility. The fact that he can get away with things that other people can't. He is angry that he is being taken off to jail. And he is angry that he is being charged with murder. And it would make perfect sense that he would say, okay, fine. I got away with it once, so I'm gonna get away with it again. Because he alone at that point is fully aware of his mental health history. I expect that the evidence will show during trial that when the defendant nears or has in the past neared points where he was going to have to face the criminal responsibility portion of his trial, the defendant would cease taking medication, which caused him to be affected by his mental health illness. But at the time that the act occurred, there is no evidence, and I don't expect there to be any evidence that the defendant was not properly on his medication. So I submit to the court that the defendant has not proven his burden of showing that he was insane. There is no evidence to suggest that he was. This statement that he made was a spontaneous utterance, and it was voluntarily given, considering the presumption of his sanity and the officer's testimony that the court has heard.
All right, Ms. Shubo, any brief rebuttal?
Just very briefly, since we started talking about evidence that didn't happen at the hearing itself, I think the evidence at trial would also show that Mr. Lowe was in and out of mental health facilities since the age of 13 years old, and that he has never had a time period for more than a year or two where he wasn't, since 13, in a mental health facility or a prison. Okay. And that would go directly to, even if he appeared sane to Detective Benton at the time of the incident or at the time of the interview, that doesn't mean that he was. And I think we have to start talking about whether or not that he voluntarily stopped his mental health. That just seems to be totally outside of the picture of this, because even if there was evidence that before the murder he stopped taking his meds to do this, that wouldn't be admissible in my point of view. Also, the state made an argument about legal insanity or sanity. I think that that legal insanity and insanity statutorily in Georgia is not the standard. It is more broadly than that.
More what?
Tell me
Broad.
tell me what you mean by that.
Well, I think in Georgia, it's very clear that it is right or wrong or delusional compulsion.
Mhm.
I think when back in the 60s and 70s, the US Supreme Court was talking about insanity, it was insanity writ large. Now I'm maybe contradicting myself. I don't know if Kaler versus Kansas that came out a year ago from Justice Kagan's opinion would tend to go against that. But I do think that when they talk about insanity, they are very clear it's the class of criminally insane people, which I think is a little different than Georgia's standard.
How so? And
Well,
why shouldn't we view it through Georgia's lens? Because criminally insane in Georgia means you can't tell right from wrong, or there's that irresistible compulsion.
yes, but when you talk about when Blackburn talks about insanity, granted they used different terms back then, but I think we're talking about more common law understanding of insanity, which is more in depth, though depending on who you're listening to, from going back to Blackstone and Hale, or you're listening to the McNaughton rule, or you're doing all of those things, there are different categories of what insane is. And I do think in Georgia, it's very clear that there are two specific things, but I think that general, they talk about in some of the very old cases being, those that are to be put away. That would describe Mr. Lowe. So I think there is definitely a difference to consider.
Well, I will look at Blackburn and I think Gardner may be more influential since that's our Supreme Court, but I'll look at both. All right. I will work through that. Let's check on Mr. Lowe and then pivot to the motion in limine. I'd like us to finish by 1 at the latest. We can do that.
Mr. Lowe, are you okay? Can you give a thumbs up?
Yes, ma'am.
Okay, do you need to take a break, or can you sit for another hour or so?
I'm sitting.
Okay, that's what we'll do. Thank you, Mr. Lowe. If you need to take a break at any time, just tell someone in the room with you and we'll pause while you take a break, okay?
Okay.
Great. I'm gonna put you on mute again. All right. Let me these papers in the right place. So the other issue we were going to work through today was the motion in limine to exclude Dr. Shao and or Dr. Subramani, Subramani, and Shao is SHAO, from testifying to their findings that Mr. Lowe was not insane at the time of the homicide in this case. And Mr. Shubo, you filed a motion in February and a couple weeks ago supplemented it with sort of a blow by blow. I don't like the fact they relied on this, and I don't like the fact they relied on that. Let's start at the higher level of having either one of them testify, because I don't know that their report would ever be, it would be made part of the record. I don't know their report will go back with the jury. So some of your concerns about language in the report or what they relied on, I don't know that that is suppressible, but we'll work through that. I think the threshold issue is, if the state calls Dr. Wanda Shao to the stand, can she say, hey, I looked at a whole bunch of materials and it is my learned opinion that Mr. Lowe was not criminally insane at the time of the killing in this case. And you say Dr. Shao shouldn't be able to do that. And I don't mean to simplify it, but basically because per Walker, we're not using experts because we're not, they can't. And we navigated this initially with, we aren't using experts, so they can't have, I think it had to do with evaluations, that Mr. Lowe can't be compelled to be evaluated because we're not going to be relying on an evaluation. It's not going to be a battle of the experts in that way. And that's where we are. There's not a court-ordered evaluation upon which any party can rely. The state went forward with having those two doctors look at historical materials and whatnot to see if they could reach a conclusion, which they did, about Mr. Lowe's sanity at the time of the killing in this case. Why should they not be able to share their conclusions with the jury? I think that's the issue, and I may have
Totally the issue.
got it completely wrong, and please get it right.
So there's part one, that they shouldn't even be allowed, period. And then there's part two, if they are going to be allowed, what they could possibly say or rely on.
Okay,
Okay.
so let's start with one.
One is the Abernathy, Walker, Nance, that I think you have all those sites, but I can give them to you again.
So I have Abernathy and Walker and Nance. Yes, I do.
Okay. Those basically say, if we don't present an expert, they don't get to present an expert. That's my reading of the cases. If that's true, then the second part doesn't really matter.
Right. So I'm going to want to hear from the state on issue one first.
Okay.
But I want to make sure you said and you can rest on, hey, read Walker and related cases. Was there more you wanted to say, or the court has spoken? Why are we talking about this?
Yes, I think that it is clear in Abernathy, Walker, and Nance that, I mean, I'm just quoting, finally, if Abernathy undergoes an independent evaluation.
Don't quote too quickly.
Oh, I'm
For
sorry.
the court reporter. It's all right.
Okay. Okay, well, let me do Walker, because that's a shorter statement. Walker versus State, 290, Georgia, 467, 2012. If a defendant chooses to present mental health evidence through lay witnesses only, the state may not rebut the mental health evidence with the testimony of its mental health expert.
And that's in your motion, page 2.
So I think I don't need to say any more than that. I think that's the holding.
Was that in the context of getting Walker evaluated, or it was in the context of, here we are at trial and there were 6 different evaluations, some favorable to the state, some favorable to the defense, and the defense says, you know what, we're backing away from experts. We're not going to use the evaluations we like. And because we've made that decision, state, you can't use any other evaluations? Or was it in the context of the state saying, hey, we need to get this guy evaluated, court-ordered evaluation, and the defense said, well, we're not going to use any evaluations. And so the Supreme Court has said, then trial judge, you don't have the ability to order an evaluation of Walker, because those are 2 different things.
Right. So I haven't memorized Walker and Nance in preparation for this hearing, but Abernathy, which is a death penalty case, specifically talked about that in since the defense was not putting on a defense expert in mitigation, that the state couldn't put on an expert. And the state had argued after the fact that that should be cabined to the death penalty only. And the court has said, no, that goes to both guilt phases and non-death penalty phases. And that was in Otis, which I can get the site. I think it's in a footnote in the motion.
It is.
Okay.
Yep, you've got that. So even if Walker was in the context of, can the state through the court compel an evaluation to maybe get a competing expert view, maybe a neutral expert view, and that's a newer case. Walker is newer than Abernathy. Abernathy speaks to the actual in-court expert saying X or Y or Z. And if the defense says, we're not calling an expert to opine,
Yes.
Abernathy says the state cannot either. And Otis says that's not just limited to the rare air of death penalty cases and penalty phase of death penalty cases.
Correct.
Okay.
And Otis kind of reaffirmed Abernathy, not on this specific point, but generally, and that was past Walker.
Yes, more recent.
More
It is
recent,
more
yes.
recent than those. Okay. All right. Ms. Love, tell me how you get past Walker and Abernathy.
Your Honor, my reading of Walker and, Abernathy being the
Because one of them, I'm interrupting you, but one of them at some point in these proceedings, Ms. Shubo said, hey, look at this case, you can't do it. And I even had to write in an order, like, that's not what it says. I can, or the state can, or the court can do something because it doesn't stand for that proposition. I don't remember if it was Walker, but I know we've had one instance when one of these cases prohibits something, but it wasn't what the state was trying to do.
Would you like me to refresh your recollection what that was?
If it's not this, then just say it wasn't this.
It was Abernathy, but the issue was that there was a rule in Abernathy that I was speaking of, and that the rule had subsequently been changed after Abernathy, not that the principles in Abernathy were wrong.
And what was the rule?
The rule was notice to the state on giving experts time,
That's right.
time before.
That's right. Okay. So not quite wires crossed, but it's not this issue.
Yes.
Okay. All right. Back to you, Ms. Love. I'll be quiet.
So Judge, what my reading of these cases amounts to is that the courts are saying that the rule which requires the defendant to submit to a state expert's evaluation is in place to allow the state to rebut what evidence the defendant's expert might put up. And that if the defendant chose to not put up an expert, the state can't use the information gathered during the state's forced upon the defendant evaluation of the defendant to rebut lay testimony. Because
but if there's an independent, nothing to do with something was compelled, an independent expert examination, you don't think that falls under this prohibition?
Would the court ask the question once more?
Well, I interrupted you. I think you were getting to where I got. So why don't you just continue with what you were going to say?
Okay. And because it puts the defendant in the position of having to decide, in order to keep his words out of the state's hands, he'd have to decide before he's even evaluated and before, he knows or has made a decision about what he wants to do at trial. He has to basically choose between, getting evaluated and therefore being subjected to the state's evaluation, and then them having in their hands information to use against him at trial, regardless of whether he puts up his own evaluator. And the courts are saying, no, if we compelled the defendant to submit to a state expert's evaluation, and because the defendant was intending to use or present his own expert, and then the defendant doesn't put up that expert, then the state can't put up the defendant's words that he gave to its expert. And that is simply not where we are. That's not what we have here at all. What we have here is, one, we have people to whom the defendant refused to give statements for the purposes of an evaluation, which is well within his right. But we also have evidence that is to say it's relevant is just too much of an understatement. The defendant has to show by a preponderance of the evidence that he is insane, or he was insane at the time of this crime. The state has the right to rebut whatever evidence they show in whatever form. Nothing in either of the cases that Ms. Shubo cited even looks to stand for the proposition that the state can't put up an expert because the defense doesn't put up an expert.
these cases are, from where I stand, speaking to the fact that the defendant is being compelled to give words, which are then used. He's being compelled to give words to a state expert for a reason. And once that reason is taken away, once there's no longer the defendant's intention to use his own expert, the state doesn't get to go use those words against him. And so this is just not that. Additionally, the courts have said in Armstead that once the defendant enters a special plea of insanity at the time of the act, Georgia law is clear that a plaintiff waives his right of privacy with regard to medical records that are relevant to a medical condition the plaintiff placed in issue in a civil or criminal proceeding. The court said and that was Moreland versus Austin, 284 Georgia 730 at 732. Rogers versus State, 282 Georgia 659, a 2007 case. Perkison versus the State, 279 Georgia 232, which is a 2005 case. Trammell versus Bradbury, 256 Georgia at 412 at 424, which is a 2002 case. All stand for the proposition that raising the defense of insanity waives the statutory privilege protecting disclosure from psychiatrist-patient relationship. Armstead said here in their case, it was undisputed that appellant placed his mental capacity in issue when he filed a notice of intent to pursue a defense of not guilty by reason of insanity. This constituted a waiver of any state constitutional right of privacy or statutory privilege in his medical health records. And by extension, the defendant is being treated by psychiatrist, Dr. Shao. His medical records, this information is not privileged. And if it's not privileged and it is relevant and its probative value is not substantially outweighed by its prejudicial impact, and the court has the ability and in fact should, according to Tolbert versus the State, which is a 1990 case, 260 Georgia 527, have an independent, neutral person rendering an opinion as to the defendant's mental state at the time. And Tolbert specifically says, one moment, Your Honor. I think I pulled up the wrong one, but Tolbert was not the case that I was looking for that stood for the proposition that the courts need to find the truth, and the court's right to have someone evaluate the defendant. Is reflected in the statutory scheme, I'm going to move forward so I don't mess myself up on the train of thought that I had.
Okay.
But, Your Honor, it's relevant evidence. It would be used to rebut the defendant's assertion that he was legally insane at the time that he committed this act. He is not being compelled to submit to any evaluation. The state, the whole purpose of this trial is to ascertain the truth. The defendant should not be allowed to circumvent just basic fairness by, his decision to put up a lay testimony. It does not keep the state from presenting a case and from presenting rebuttal evidence to allow the jury to accurately determine whether or not the defendant was insane. He does not simply get to say, oh, I'm putting up lay people and that's it, and you're stuck with lay people as well. The people that the state wants to call as witnesses, Dr. Shao and Dr. Subramani, they are not only fact witnesses that would be able to testify about their observations of anything that was said, but they are experts who also can talk about what psychotic episodes look like, what psychosis looks like. And in this particular case,
Let me pause you for a second because you raise an interesting point. Were you intending to call either of those doctors to also do that? In other words, what I call educational experts, like the gang expert. Gang expert doesn't end up saying like, that guy's a gangster. The gang expert says, here are indicia that someone is a member of a gang. It's a tattoo that says I'm in a gang, or they carry a bandana, or they're on Instagram and they perform with a certain group. That's an educational expert. And it sounds like a function you would have either doctor perform is to educate the jurors on what is meant by a psychotic episode, or indicia from their experience that someone is insane. Not a final conclusion, a la Anique Whitmore. I'm not concluding that this child victim is telling the truth, but I'm helping you understand, jurors, why she might not be crying right now in court, even though she's facing the guy who she says did these terrible things. Would you use either of them in that way?
Absolutely, I would have to, because.
So pause. I take your objection, your motion, Ms. Shubo, to be ultimate issue objection. They ought not, Shao or the other one, Subramani, be able to come in to say, we conclude, we opine, Mr. Lowe was not insane at the time of the killing.
So 2 answers. One, I think
Certainly that.
Certainly that under 704B, like that's not even on the table in my mind under 704B, because it says they can't do that. But also, I think Abernathy, Walker, and Nance say they don't get to do anything. I think if it was cabined to an educational expert, I would want to know what, first I would object writ large, but if you said, no, we can do that, then I would want to figure out what exactly that person was saying and cabin that. I also might have a problem, and this is off the top of my head, with Dr. Shao or Dr. Supurani doing that, because if they were to testify, especially if she wants them as fact witnesses, which is category 3, that's a whole nother thing, to testify both as fact witnesses as to what they've seen or heard, and then as being the educational expert, there would be a conflation of those 2 things. Because
typically, not to pick on Ms. Whitmore, but she would start her testimony by saying, I've never met the young lady who is the alleged victim in this case.
Right.
I'm here to tell you, from having interviewed 10,000 kids, how kids handle things differently, and what you might look for if you're watching the interview, consistencies and details, all the kinds of things. But she's not a fact witness. It is purely education. Your concern is that there could be mixing, or?
My concern is mixing and placing the wrong value, sort of as a relevance issue, and as well as a 403 issue. So 402 and 403, because if they're going to get up there and say, I'm his doctor. I saw this, I saw that. And by the way, I didn't see X, Y, and Z, and X, Y, and Z is what a psychotic break looks like. Like if those are all things that they could say within educational expert, this is what a psychotic break is, and fact expert, I didn't see anything that looks like a psychotic break, then you're getting into the same kind of testimony that I want to avoid, that I don't think is, not just want to avoid as like a preference, but I don't think is allowed.
Because of Abernathy and Walker.
Because of Abernathy and Walker, and then the additional, assuming you don't agree with me on Abernathy and Walker, the limitations that is part 2 of what I'm arguing, all of the, yeah.
Okay. All right. That's helpful from both sides. All right, back to you, Ms. Love.
Thank you, Judge. And just to touch on something that was just said, so the idea that a fact and an educational, a fact witness can't or should not be an educational witness because they can't or shouldn't be conflated.
They're often both. You don't have to, they're often both. The issue here, though, would be if I conclude they could only be educational witnesses, we just need to guard against them slipping up and saying, well, for example, a psychotic episode is X, which, that's not what Mr. Lowe was here for. There'd need to be that bright line. I'm not saying I'm drawing any lines right now, but most medical experts will first educate and then say, and here's what I saw with this person. So there's not an issue that's not a legal issue. It would only be an issue if I conclude that neither of the doctors you've identified can talk about specifics concerning Mr. Lowe, which they have, because they've spent a lot of time with him.
Thank you, Judge.
Sure.
And so the defendant's motion, I think in the supplemental motion in limine that they filed most recently, their assertion is that they do not, there was a specific portion of their motion where they objected to Dr. Shao or Dr. Subramani opining that the defendant has antisocial personality disorder. Interestingly enough, the defendant, according to the motion, has no objection to the doctor's diagnosis of schizophrenia, but objects to the alleged diagnosis of antisocial personality disorder. And similarly, they don't object to anything that the defendant said or that was reflected in the Fulton County Medical Jail medical record since September 2007. They don't object to observations within the Grady Memorial Hospital records, but they object to the records that the defendant made while at Georgia Regional Hospital. And I'm assuming when they list these out that they're saying we don't want that report or this portion of the report shown to the jury, and further assuming they are wanting to not have any mention of things that were observed or
Well, I'm going to let Ms. Shubo, if we need to get there, explain why she's flagging those different things. I want us to stay at that threshold of can the state call an expert anyway? And I guess I did a bad job of outlining it. So either of the doctors could share their perspective, I guess, as to, given 704B, they're not going to be able to say, hey, based on everything we've looked at, not criminally insane at the time of the killing. That's not what they can say. I think, no, go ahead, but what? So what is it that they'll be educational. They'll certainly be that. What else?
But what I would expect that they would be able to say is that this is what, and this is along the lines of educational witness, but this is what, this is the difference between a psychotic break or a psychotic episode, or this is what someone who doesn't appreciate the right or wrong aspect of their actions looks like, or this is what it looks like when someone is acting under a delusional compulsion that overmastered their will. This is what it looks like when you have schizophrenia. This is what a schizophrenic psychotic episode looks like. This is what an antisocial personality disorder behavior looks like. And so they should be able to talk about that because one, it's outside the ken of the average juror. It's outside the ken of me.
But how does it get in front of a jury if the defense isn't going to put it there? I don't know exactly how they intend to prove this up. They do have a little bit of burden, the insanity piece. But if they're not going to have someone come in, they're not, to say, well, gosh, he's diagnosed with schizophrenia and a social personality disorder. That's what these things mean. And people who have that seriously enough can become so detached from reality, they don't know right from wrong, or they're subject to a delusional compulsion. And that explains what happened in this case. And so jury, you should find this person not guilty by reason of insanity.
So when the court says, how does the jury or how do the doctors get to that if the defense doesn't introduce that or doesn't put that up?
Right. Why would schizophrenia come into the trial at all if that's not where the defense is going in showing, meeting their burden of showing the insanity? Because
however they're going to do it, I assume they would leave it to the jury to sort of draw conclusions from what some layperson sees and opines as abnormal, in the same fashion that Ms. Shubo's line of questioning with Detective Benton was, that's not normal, is it? That's not what a sane person would do, admit this. And so then they want the jury to draw this leap that because he, for instance, didn't stop stabbing when his first roommate walked in, then, that must mean, because they can argue whatever they like, that must mean his will was overmastered by a delusional compulsion, or he didn't know it was right or wrong, rather.
What would either of your doctors say specifically about Mr. Lowe? What part of their testimony do you foresee? If I say denied to Ms. Shubo's motion, you can bring in either doctor or both. What would they be saying that's not educational? Or would they be purely the unique Whitmore version for rebutting an insanity defense?
That's not educational?
Yeah. In other words, that's tied to, well, let me tell you about Mr. Lowe.
That Mr. Lowe has consistently given a specific reason for his actions. And he has consistently said, he owed me money. This is reflective of, and they don't overlap, but this is reflective of an antisocial personality disorder, not reflective of a psychotic episode due to schizophrenia or some other mental health diagnosis that he has. They will say that the defendant's representation that, for instance, he took it too far, or maybe he should have stopped, or
but let me just, I know we're bleeding into the part two of the defense objections. You're saying that at some point, Mr. Lowe said to someone, yeah, I took it too far. To whom did he say that? I mean, obviously not Detective Benton, because it better not be Detective Benton, because we've heard the three
never
things.
said it,
Yeah.
no. He said it to his brother.
His brother.
Yep.
Okay. And, okay, that's not a bad example for you. I'm just trying to work through what scenarios where you might be asking one of the doctors to say, let's talk a little bit about Mr. Lowe's situation specifically, as opposed to generically, what's a psychotic break and whatnot, because I share some of Ms. Chabot's concerns. If what the doctors relied on is something that might otherwise be suppressible for constitutional reasons, not because it's hearsay. Experts can rely on hearsay. They're reading learned treatises all the time, all that stuff. But if it was an evaluation he had to undergo in connection with another case, and just his defense attorneys didn't object at that point pursuant to Abernathy and whatnot, then they might be saying, oh yeah, when he told that doctor I went too far, they need to not be talking to the jury about that, because that's not an example of something he did or said that they could say that's indicative of antisocial personality disorder as opposed to being insane.
Okay, I expect that I will ask them about, and they'll speak to the fact that the defendant, when a person with antisocial personality disorder will do things when they feel like they can get away with it. And this is my very poor representation of my, conversations with the doctors. They do things because they just don't care. Because when I specifically ask, for instance, Dr. Shao, when I specifically say, what's the, like, how do you know? What is the difference between, why isn't a person with antisocial personality disorder, like, why aren't they able to stop themselves? Why are they not able to stop themselves? How can you say that they don't know right from wrong? Her response is, because when they think they cannot get away with it, they won't do it. For instance, Mr. Lowe, during his time at DBHGD, he told a petite statured female staff member, bitch, go get my orange juice before I fuck you up. And yet when the larger statured male staff member comes in, he is as polite and as orderly as can be. And that that's routinely what he will do. And so similarly, on the day or night that this stabbing occurred, he's stabbing Mr. Giddens because, as he's saying during the stabbing, he owes him money and he's angry about it. I expect that the witness is that, I won't get into that part, but when the roommates that saw the stabbing walked in and said, hey, stop, they're not willing to get between him and the knife, but they're also not willing to physically try and restrain him. And Mr. Lowe, just like with the staff members, knows who will and who won't do certain things.
But when the officers show up, it's like,
came,
I'm done.
That's it. And that is an important piece of information, that distinction between behavior, to share with the jury. And it's important for the jury to put that in context, in the proper context. And I can't do it through argument. And I don't believe that that's something a normal layperson would know.
Okay. All right. That's helpful. Anything else you want to share with me at this point?
Unless the court is asking me about everything I expect they'll take, then no.
Well, we may have to work through that. I need to get through the threshold question first of whether the two doctors could testify. If the answer is yes, they can, then it's to what? It sounds like everyone agrees not to, in our opinion, he was not insane at the time. We're not going there, but that leaves a lot of real estate to cover. There's the purely educational piece with no reference to information they have about Mr. Lowe, regardless of how it's obtained. To me, that's classic educational. Let me tell you, you'd ask them, what is a psychotic break? What is this? What is that? And they can talk all about that. It gets a little more gray using one of your examples of something they directly observed, the way in which Mr. Lowe interacts with small staff members and big staff members. It's not compulsory. It's they're just watching how he interacts, and it's not their review of a police report or anything like that. And then we move over to some of the things that Ms. Shubos flagged, where maybe those are documents upon which they ought not to rely when they're talking to the jurors if they're testifying. So it may be in the end we'll need to have you explain each specific example of what I'll call Mr. Lowe conduct that they'd be talking about. Or it could be that I can construct a pretty bright line rule. If it's something that they saw directly or their staff experienced, something like that, that's very different from in reviewing a record from 8 years ago when Dr. So-and-so says that Mr. Lowe said this. That's classic antisocial personality disorder. Well, we need to understand in what context was Mr. Lowe having to speak with that doctor? Was it a court-ordered conversation? And if it was, then it may be that that's something that either of your experts need to stay away from. Well, more accurately, you need to stay away from, and don't ask them about that. I'm not in a position to get that granular. So right now, no, you don't need to go through every example. You'd want them to. I have to do some thinking first, and then we might have to talk again.
And having clarified that, there are three other things that I think I need to at least touch on right now. So even if the court ultimately says, no, you can't use this over here thing that you didn't observe that was written in a report or that somebody said, I necessarily would want them in an expert capacity to talk about hypotheticals that I expect other people will say that they observe.
And hypotheticals are always fine. That's what experts are for. And so if they're up there, you'd be, well, what if this situation happened? How would you describe that?
And second, the defendant, not just to orderlies, but and it falls sort of in that same category. But for instance, to one of his evaluating doctors, he threatened to kill the doctor, and because he was mad, because that's what a person from my perspective with antisocial personality disorder would do. But then when one of the other patients, defendants at the hospital did something that angered the defendant, he told the doctor, hey, you need to put that person out because they're doing stuff that is wrong. And then the doctor says, but you threatened to kill me. And he said, but I apologize. So yeah, I knew it was wrong. Yeah, I threatened to kill you, but I apologize. And so that's water under the bridge, put her out. Those sort of things I would want them to be able to talk about. Those are things that happened, they weren't the result of some compulsory examination process. These are just things that he did.
Day to day.
Right.
How are the two examples you gave me, we're opening a whole other can of worms. How's that not 404B? If he's threatening to kill a doctor, that's a bad act. Shouldn't do that. You're not introducing it necessarily to show he's a killer. That's not your point at all. It is indicative of something different. But I'm again a little nervous that there are things that you're aware of, and it may be the defense is aware of as well, that Mr. Lowe says. It sounds like it's more words than actions, but maybe even maybe shoved someone while he was there. in a manner that is illustrative of a point you'd want the doctors to make. But all that stuff doesn't become not 404B in terms of notice and making sure there's a proper purpose. It sounds like it's dripping with proper purpose, but it's still something that ought not to come up in the middle of trial with the defense not having heard, wait a minute, you just said he threatened to kill you. This is a murder trial. That's not something we should be hearing about the first time. I'm not saying it's the first time they heard about it. It may well be, but we would need to navigate some of these things, not just can an expert talk about this in the face of Abernathy and Walker, but even if those didn't exist, we got to make sure that what they'd be describing is otherwise admissible.
And Your Honor, has touched on exactly what is not lost on the state. As I put together the way that I would have the doctors explain the distinction between psychosis and antisocial personality disorder. Yes, I would be introducing it not to show his poor character or that he acted in conformity therewith, but to show the basis for a diagnosis, for a medical professional's diagnosis of antisocial personality disorder versus psychosis due to schizophrenia. But it is not lost on me that if I am going into those specific things, I believe I do need to notice the defendant. They have the information. It is all a part of the evaluation materials that we've been given from DVHTD, but that if I intend to elicit that, I need to say, hey, I'm going to bring this out, and I will.
Okay.
There were also statements that the defendants, and this is the last thing, the third thing, statements that the defendant's sister made regarding his actions surrounding the murder itself. And his sister she told staff members at DVHTD about it. His sister is now deceased. And so because it's referenced in the notice or motion that the defense filed, and it is also something that the doctors looked at in coming to their final opinion about his actions. I believe that one, I need to bring it to the court's attention, so that's why I'm saying it. She also said that the defendant had stated his intention to kill the victim in this case over the money that he believed he owed him or stole from him. And he had actually gone to his work or something of that nature with those intentions in mind beforehand. And again, this is going to fall under 404B because his sister said, I believe that he was high on cocaine, that he had ingested cocaine or there was cocaine usage. But these are words that his sister gave, not to the police, but to staff at the hospital during conversations in order to, I guess, educate them or to assist her brother, because she is going there to visit him. So that's the last thing when the court asked if there was anything else that I wanted to bring up that I felt I should take up.
Yeah, so that's a big one. So you're saying that you've got records or maybe a person to whom she spoke, or is this going to be hearsay within hearsay, where sister came in and said, Mr. Lowe was planning this, which is pretty powerful. I'm not insane evidence because there was a plan that was pursued as opposed to I was overcome at the moment because this guy had my money.
The records of the defendant from DBHTD reflect that. I believe that the doctor to whom the sister spoke's name is connected with that. When I attempted to reach the sister to talk to her about it, that's when I learned that she's dead.
She's dead, but
Mhm.
then there's the person to whom she said it. But I guess these are business records. I mean, I don't know how it would come in unless you've got, I don't know, it would come in anyway. I mean, it is something someone said, and the declarant is unavailable. So, and we don't need to work through it right now, but you,
I would argue that it has the particular guarantees of trustworthiness, that it's not testimonial in nature, that it's and that let me get the.
let's not navigate it right now. I need to make sure if there is a notice requirement for trying to rely on that type of exception, you got to make sure you comply with that. And we'll certainly need to work through that piece. To me, that's independent of, if you were to call Dr. Shao to get that in, that's not using Dr. Shao as an expert in any way. You wouldn't need to get Dr. Shao qualified as an expert for her to say, she'd effectively be a records custodian, because it doesn't sound like you are currently planning on calling a person to whom those words were spoken.
I wasn't planning on calling. I wasn't initially planning on calling that person.
So you just need to work through then how that would come in, because then it's someone who didn't generate the document saying, I've reviewed a document, and in that document, if it's not hearsay, it says that the sister said da 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 da. And so you need to provide a basis for each piece not being hearsay. The sister's one you were about to get into, indicia of reliability, et cetera. But you don't have the person to whom it's spoken. You've got another piece of hearsay, some record, and that maybe it's not hearsay, but that's for you to work through. But it also just make sure if there are any notice requirements for doing anything like that, you're complying with those. I see what time it is. I want to give Ms. Shubo a chance to respond to some of what she heard. And if you've had a chance to think more about the educational expert as opposed to the fact expert, because first of all, that's a distinction I come up with. I mean, there are experts who are allowed to testify under the non-Daubert version of criminal expert stuff, but in the federal side, the Daubert version of expert testimony, who aren't coming in and saying, here's the reliable method I use. I'm going to educate you on Islamic fundamentalism and how young men are recruited online, and that jihad trial after jihad trial, people can come in as experts and educate the jurors. And certainly there's not a defensibility to say, well, I'm not going to use an expert, so you don't. This is different. But why is it that someone who's going to come in and not talk about Mr. Lowe in particular, but is going to talk about psychoses and schizophrenia and whatnot, why would that not be appropriate under the cases you rely on?
So I think they set out firm rules and holdings. So there's that. I think it is a much closer question if there is no connection at all to Mr. Lowe. And if there are no hypotheticals about things that Mr. Lowe did or didn't do, because I didn't bring those cases today because I didn't think we were going into it, but there's a whole list of cases from the 11th Circuit and others about backdooring hypotheticals with evidence that actually shouldn't have come in. And so if that's something we need to get into, I'm happy to do that. So putting that aside, I think if they called an expert who was not Mr. Lowe's doctor, who could just come in, another psychiatrist that they hire, they come in and say, this is what schizophrenia looks like, this is what antisocial personality disorder looks like, and these are some of the characteristics that you would be looking for. I would still object under Abernathy, but all of my additional objections that are the supplemental motion.
The material-based
The
objections.
material-based ones, I don't think I would have that one anymore.
Okay.
Just-
But if it were Dr. Shao, just to pick one of the two, and she were limited to doing Anique Whitmore type testimony, here's what you'd see with someone suffering from a delusional compulsion versus antisocial personality disorder. Why does it matter that she spent time with Mr. Lowe?
So our argument would be, and again, thinking this through right now, so I might have additional ones, is that if she is going to testify to what schizophrenia looks like and what antisocial personality disorder looks like and all of those things, then she shouldn't be allowed to say she's Darryl Lowe's doctor. She shouldn't be allowed to say, I'm giving you information that is included in my relationship with him. I think just like Anique Whitmer doesn't know anything about anything, right?
Well, she knows a lot about a lot of things. She would have only watched the video of the Center for Children's
I did not mean
Advocacy.
to demean her knowledge base. Doesn't know about the specific things. I think if they want to use Dr. Shao, I would still feel uncomfortable, but if they wanted, because of bleeding of stuff, but if they wanted to use Dr. Shao to say, this is what schizophrenia is, this is how it manifests itself, this is what antisocial personality disorder is, and this is how it manifests itself. And we came up with a kind of cabin list of what was allowed. I think I would still have the Abernathy problem, but I wouldn't have any other problems with that.
Okay.
So.
And if the hypotheticals are based on the facts and circumstances of this case, what's the objection to that?
Well, it's backdooring actual evidence that would not be admissible. And I think
But
there,
what would, let's say, for example, Dr. Shao testifies towards the end of the trial, which is often how it works, tying things together. And already the roommates have said, yeah, we walked in and he didn't stop stabbing, but Officer Smith walked in and he saluted the officer and said, now that you're here, I'm going to stop stabbing. And then Ms. Love were to ask Dr. Shao, well, if someone has antisocial personality disorder and they're in an episode, what typically gets them to stop? Well, they're able to tell it's law enforcement and they'd stop.
yeah, no, I don't have a problem with that. If the expert witness watches the trial and then base her hypothetical, I mean, besides the Abernathy, I'm just putting that out there for everything, watches the trial and says, this evidence, only the evidence that was brought out at trial that was admissible and not anything that dealt with Crawford and not anything that dealt with all the other things that I listed, any evidentiary problems. Watch that. And then there were hypotheticals that were drawn from that. I don't think that would be a problem outside of Abernathy. If she's drawing on hypotheticals that come from evidence that would otherwise be inadmissible, that is what I would have the problem with.
But okay, I guess you're going to need to send me some cases. Let's say I find that the state cannot share with the jury that Mr. Lowe threatened to kill a doctor.
Mhm.
Whether he meant it or not, that's just not coming in. That's too prejudicial. 403, that's why it's not coming in. That's not my ruling, but let's say that was my ruling. Why could there not be a hypothetical based on that? There's no evidence that it happened, but Dr. Shao wouldn't be saying, oh, and by the way, that actually happened.
So there are cases that I did not prepare for today that talk about if an expert is saying that a jury would understand that to be facts in the case. And I can find those cases. I found them when I was looking at Goldstein and
I'm not
Sanchez.
expecting, I'm trying to understand the rationale, because just going back to putting on my Anique Whitmore hat, she's asked questions about all sorts of stuff that happened in the case, didn't happen in the case. The prosecutor isn't saying, well, something else that happened in this case is that the defendant did X, when I've said that's excluded. It's just a hypothetical. If the child responded this way, or if what happened to the child was X, and then Anique Whitmore can respond, and your colleagues, excuse me, they're not blowing up. Like, it's a hypothetical. So I don't know.
I'm happy to provide all the cases that I found. Like I said, I didn't.
Maybe
I
not
usually
all
like-
of them, but like one or two.
Okay. I will try to show you the cases that I found, the ones that are most on point and the ones from the 11th Circuit, because we kind of follow them.
Yeah. Okay. What else did you want to?
So I have lots to say about the supplemental motion to go through it. I don't know if we're there, and I don't know if there's time.
There's not time. I don't know if we're there. I don't know that we'll get there. We may need to, we'll have to talk again anyway, but we'll talk again if what I conclude is that Abernathy and progeny are all about bringing someone in to say, I've evaluated him and here's my opinion, which is really the thrust of them and not what an educational expert would do. Then I see your points on all these, but if neither doctor is going to be asked, well, hey, Mr. Lowe said, I don't know what's in the supplemental incident report dated May 8th, 2010. That's number 5 in there. But let's say in that supplemental report, it's got something about what Mr. Lowe said, and I had suppressed that. If the state isn't saying, well, if Mr. Lowe said XYZ, how would that inform your judgment about this being schizophrenia or something like that? And frankly, that'd be a bad question anyway, because it's getting the ultimate issue of it's not insanity, it's schizophrenia. That's for the jury to decide. But I think the state is entitled to educate the jury on, well, what the heck are these different things? What is schizophrenia? Does it mean to be criminally insane? And some of that comes from the law, but some of that might come from subject matter experts as well. And so if they may have read that incident report, but if they're not talking about its contents in response to questions, I don't know what the issue is.
I'll provide with either a supplemental brief or at least an outline with cases. I literally just read a law review article talking about this that I can provide as well. And I don't know if you care about law review articles. So there are definitely concerns. I think there are ways to cabin that.
Well, I'm all for cabining, and a lot of that would come through structuring the way in which either doctor could be examined.
Yes.
But just so you guys aren't left hanging, I will read these cases again. I am leaning towards saying either or both could be called to testify for sure as educational experts, and a Nick Whitmore or gang guy. And with that would come hypotheticals. I need to be educated on what would be improper hypotheticals, because there won't be any improper hypotheticals. I'll be guided by that case law. I'm less clear on how we would work through, well, what about that time he threatened the doctor? But that's more of a 404B, 403 that you're going to need to work through, Ms. Love, in terms of notice and whatnot. The sister saying he'd been planning it for a while, my words, not yours. You're going to need to present the it's not hearsay explanation so that we can all think about that before the doctors could get, well, any witness. That has nothing to do with an expert. I mean, that's the only way you have that is through a business record, if it's a business record. And so you'd need to figure out how that would come in.
Just to throw out about that, I would also have a Crawford objection to that if she said it to a forensic doctor, because I believe that all the forensic doctors, anything said to them or any of their work product would be testimonial because it was for the purpose of prosecution.
Yeah, so I don't, that's a good question. I don't know when in time that happened and what, if 5 years ago, Mr. Lowe's brother was having a conversation with a doctor. Hey, I'm here to see my brother. How's he been? And they're talking and the brother says, and by the way, Mr. Lowe's been telling me he had been planning to stab the guy for a while. Maybe it's forensic, maybe it's not. I mean, 5 years ago, I think it's more taking care of Mr. Lowe than I am talking to you. Context is everything. If that doctor were talking with the sister to say, I need to learn more about this person I'm evaluating because it's in connection with this criminal action, I bet you're right. And that's an easy one then to rule out, is that that's just not something that comes in. The sister would need to come on in, or someone else to whom she told it, not in connection with preparing a prosecution.
I also think I'm about to annoy you again, but I think any statement of the defendant has to be again evaluated under Jackson-Deno because they took place while he was incompetent. And granted, Fife says they're not the same, but he is definitely dealing with severe mental health issues.
Yep.
You,
But you're going to get me some cases about hypotheticals.
yes.
I'm just thinking about next steps because we need to wrap up in a few minutes. You meaning the defense will send, and obviously what you send to me, and it's fine to send emails to me.
Okay.
Send them to Ms. Nelson and obviously Ms. Love and anyone else on her team that she wants to be copied on there. But it's just send it to me. Include Ms. Nelson and the state. And you don't need to have a big write-up because, hey, these are cases about improper hypotheticals.
Okay. If we get to the point that you are thinking of allowing the expert, then I think we need to go through each of the points in that. Obviously, we don't have to do that today.
We're not doing it today. We need to work through what their testimony would look like, because if it is purely educational and then hypotheticals, we'll talk again, but you'll need to tell me how, and it may be more cases you've got, or this law review article, but I don't know how that would make their educational and hypotheticals improper, assuming they're proper hypotheticals.
Yes.
All right.
And Your Honor, I just have a quick question with
Yeah.
respect to hypotheticals. So does the court include, just if that were the case, you said purely educational, would the court be saying they could not even talk about their own observations as to the defendant?
So grade one would be they come in, it happens to be doctors who have cared for him, but all they would be doing is educating the jury about the terms and concepts you want them educated on. That'd be grade one. I think you'd be able to ask them hypotheticals. I'd be shocked if the case law is you can't ask no hypotheticals, but that's not what Ms. Shubo said. She said, let's make sure the hypotheticals aren't improper ones. So grade one would be, we will talk to you about things that you, the prosecution, would then connect to Mr. Lowe. You know, I asked the doctor about, what do you think about a scenario where the stabbing happened this way? Of course, that's this case. Or I asked her, well, if the stabbing happened a different way, that's not this case. And she said, that's an example of it. But ladies and gentlemen, that's not this case. And here are the 10 reasons why. That's like pure Anik Whitmore. But the two people you want to call actually know Mr. Lowe because of the care they've been providing him. And so I don't know that it would be a problem for them to talk about, assuming it's relevant and it doesn't run across. Sure, there'll be concerns from the defense, but assuming it's relevant and there aren't other hurdles, then having them talk about their interactions or observations of Mr. Lowe seems to be appropriate. They are, after all, his doctors. But it would need to be relevant. How he is behaving today, I don't know, sheds a whole lot of light on how he was behaving back in 2010, given all the care he's been receiving, unless you're able to show he was under the very same care, all the same circumstances then. We know that's not the case because he was in a rooming house. But no, I'm not saying categorically they could not talk about their own observations of Mr. Lowe. And I appreciate that they've had those observations, not just over the past month, but it's an extended relationship. But you'd need to help me and the defense know, for what purpose would you be asking them, hey, how's Mr. Lowe been the last year or so? Mm-hmm. And then I'd be in a position, as would the defense, to say, well, that's not relevant, or I at least could say, I don't have an issue with that. So I think a project for your side would be to prepare a fairly detailed outline of your examination of either of the doctors. I would hope you wouldn't call both to ask them all the same things. If you started with Shao, asking Subramani the same hypotheticals, I'd sustain objections to, as asked and answered, even though it's a different witness. So unless one of them has something real unique that the other doesn't, I assume you just call one. Not saying you can't call both, but it need to be real clear why the second was being called. And I say that only because just prepare one outline, but hey, this is the kind of stuff I'm going to be asking, so that then I can say, well, why would you ask that? I get it. Great. That's relevant. You should be able to ask that. But then Ms. Shubo will be able to say, well, the only way she could answer that is because she reviewed this transcript of interviews from Dunikowski, and that's whatever it is.
So when we're talking about Ms. Shubo's argument that the statements are inadmissible because they're not voluntary, because he was not competent, why he was in there.
Her point is simply, anytime anyone, you, me, the defense, will be asking a witness, well, what did Mr. Lowe say? I need to be thinking, well, wait a minute, is that, well, that's not exactly right, because if we'd need to work through the context in which it was said, because Mr. Lowe saying to his brother, I was happy that I stabbed this guy because he had it coming and I've been thinking about it for a while. I don't understand. Ms. Shubo will get a chance to articulate, but there's no voluntary analysis of that. It's something he said. There is not law enforcement. I mean, if he was walking down the street singing a song about how happy he was, he had killed this guy, and Fred Smith is walking up the street, I don't know why Fred Smith couldn't come in and testify. These are the words I heard the man saying. Right. That those were words coming out of his mouth. Those witnesses wouldn't be prohibited from saying he had blood on his sleeves. The fact that the jury could find he's insane, the fact that he had blood on his sleeves, someone wouldn't be precluded from saying, this is what I observed, I heard, I saw, I smelled, he smelled bad. So I don't know that that applies to every statement Mr. Lowe makes. But if Mr. Lowe is making a statement to a doctor who is asking him questions because it's in connection with criminal investigation, there's certainly a different analysis that we need to work through.
Okay. And so when we respond or when we present to the court those things in writing, one of them would perhaps be why because their argument is that he wasn't competent, so therefore it's not voluntary. But then the argument would also need to speak to. Well,
it needs to be better than that, because Fife says you could be not competent and it actually could be a voluntary waiver of your rights, which to me is a higher hurdle than these words just fell out of his mouth. That's our scenario, the statement that Benton took down. I don't find that it was induced or tricked or extracted from him by anything law enforcement did. It either is coming in because it was spontaneous, or it's coming out because it's not coming in because he was not competent, but he was insane at the time, or whatever the right standard is going to be. I think it's that broader insanity that Ms. Shubo was pointing to, but it's the I word, it's not the C word.
Understood.
Yes, and just to follow up, yes, we know he was not competent. Was he also insane at that moment? And right. I didn't mean to conflate the two of them.
No, you didn't. And I'm not going to work through, was he competent at the time or not? It's just, that's not a question I need to answer.
Correct.
In connection with things that he said to Benton.
And I agree, if there was something completely unrelated to his treatment or anything that happened in the forensic hospital, I think that is not a Jackson-Deno analysis.
Right. It gets harder with Georgia Regional because he is there in some ways in connection with this case.
Correct.
That doesn't mean I think everything that happens is investigative, but we need to be thoughtful about how we use things that he said. Not that people observed. He moved slowly, he moved quickly, but things he said, it becomes more complicated.
In response to specific questions by personnel and staff.
Right.
Okay, understood.
Witness list. Let's talk about witness list. I am frustrated that the concept of witness list is coming up again. Why would Ms. Shubo why would the defense not have a witness list?
Judge, they don't have all of the most up-to-date information. I can give them all the most up-to-date information that we have for our witness lists, for our witnesses. We have given them a witness list, and we have given them the names in the reports that are the subject of the 404B matters that the court has admitted. We will give them the most up-to-date information we have before the end of this week.
What about the roommates? Are they people, you have that? Okay,
Not on a list, but those are the only two people we have definitely updated contact information.
okay,
So the two kind of most important we have.
sure. What's your next tier of most important? Golly, I wish I could talk to them tomorrow.
The 404B witnesses, we have no idea because they're so old who it would be if the state is trying to enter it through record, like through court records, or are they actually going to have a witness, or because we may have objections to the court records that I would
Sure.
want to articulate prior to.
So end of week is tomorrow. If you don't, by 5 o'clock tomorrow, have updated contact information, meaning best the state has.
Right.
If they're giving you a number that's a dead number, it's dead for them as well.
Yes.
But what won't work is you get an old number and then on Monday when I start fussing, like, oh, we didn't give them the cell phone number that we have for that person. Whatever the state has that is current for folks, please get to the defense by 5 o'clock tomorrow. And then defense, please send me and Ms. Nelson and the state a list of folks for whom you got nothing by that time. And then we'll need to work through, because trial's not far away, what we're going to do with those witnesses. Now, if the state tells you we don't have anything, they don't have anything. And it's actually their problem and not yours, because they're still looking for that person and they may need that person. And I'm not going to fuss at the state if they don't have anything. But as soon as they get it, there's going to be this ongoing, hey, investigator found the victim in the 404B, and here's his address and his phone number. Once Ms. Love gets that, that's an email that gets forwarded straight to Ms. Primovic and Ms. Shubo, so they've got it as well. Unless that person said, I don't want to talk to anyone else. But then the email that goes out is, we can get you in touch with this person for that person to tell you he doesn't want to talk to you. And I'll always respect the privacy, security concerns. Given how old these things were and where Mr. Lowe is, I'd be surprised if that's what people are saying, but we'll respect it. Otherwise, hey, we just found this person, same day delivery to the defense.
And so we have the reports, and I assume that the names are going to come from them. But if there is someone not listed in a police report or any discovery that we have, we would like that name, as even if she doesn't have contact information, but that name as soon as possible, because we'd have to investigate that.
Sure. Are there people you're looking to call in connection with 404B whose names I wouldn't be able to find from looking at the materials that you shared with the defense?
There are people whose names we don't know that we're attempting to locate. For instance, in the aggravated assault, the officer's report is just bare.
Yeah.
He doesn't even talk about who made that 911 call.
It's probably literally typed. It probably wasn't even on a computer.
And so so we're one of the things the investigator is working on now is tracking down those people who were in that house and who the person who was over or on that house.
Okay, but you don't have the name. You can't provide the name, but it's helpful. I hope you guys talk outside of being in court with me, because it's frustrating if you don't. And so just letting the defense know, we're looking for these people. We don't know their names, but we're looking for this cast of characters, people who were in the house. Good luck finding them. But if you do, as soon as you find them, you pass that along. And it will be helpful for all of our planning purposes if we're on the eve of trial and, you know what, Judge, we have found no one in connection with the ag assault. So we're going to raise the white flag on that one.
Right.
Because if you find them in the middle of the trial, we're probably not going to hear about that ag assault, because the defense, I'm not going to require, even though there may be two lawyers in there, they say, all right, we're going to break for a day so they can go meet with those folks. There'll come a cutoff point where if it hasn't happened For 404B. If it was like the roommate who saw the stabbing happen, that's someone who might parachute in at the last second if you found them. But you've already found them, so we don't have that issue.
Right. That, yes, that is perfectly understood and understandable. And we do talk. I haven't given like up to the minute sort of updates, because I anticipate that we will be successful in getting some of the people that I have asked our investigator to find. And so rather than saying, hey, we're looking for, it may be a matter of, ooh, everybody's dead and I can't use anybody. And then I would tell her. So
Right.
I wanted to give the investigators that opportunity first.
Let's do this, given where we are in the calendar. If you would please give the defense an update at the end of each week. There aren't that many weeks left, but so tomorrow and then next Friday as well, where you are in terms of finding people, or if you are just giving up on a particular line of attack to say, we're not going to use this set of evidence because they're dead. We can't find them. They're out of the country. That will just allow folks to focus more. If this were not a mental health issue case, it wouldn't take very long to put it up.
Right.
Because it's so old. I mean, it's just a handful of witnesses. They're the roommates, they're the police. It's not like you're bringing in DNA or this or that. And I don't know what the defense would be if there weren't a mental health defense, given what I understand that case to be. So for it to last more than a day or two, other than that, we're going to have shorter days if the sheriff is able to help us transport Mr. Lowe each day. It's going to be things that are ancillary. It'll be our experts. It'll be the 404B. And I share all that to say we can then lop off entire pieces if the state learns we really want to use that ag assault. Judge gave us a good ruling, but we're just not going to find the right people. We'd be left with someone reading the police report into the record, which isn't how you'd be able to prove it up. So the sooner you're able to make those decisions and share them with the defense, everyone's planning gets easier. Okay?
Yes.
Don't hesitate to send an email to me and Ms. Nelson over the next couple of weeks if there's a hot button issue for either side. I can't promise I'll jump on it right away, certainly not next Monday. But on other days, I'll turn to this. I've had bad luck. My last trial calendar, jury date, and then the one that's coming up on the 5th. I think we're not going to be able to go forward on anything, mostly because there are no conflict defenders and no C3. And I only have one full-time public defender. And so we're having trouble getting cases ready. It's just fact. I don't want that to happen with Mr. Lowe. So waiting until the day before jury selection to say, oh, there's this issue that you knew about today. It'll be harder for me to be chipper about that. So please flag things earlier.
Try to get my motions in limine in sooner rather than later.
Okay, you're envisioning, what other, I guess it depends. The list is growing as you hear Ms. Love talk about things. Okay,
2 came to my mind while she was talking, so I'll add those. I have a 609, depending on what, when he's testifying for incidents that did not come in on the 404Bs. Most of them are very old, so we'll be arguing that those have to stay out, things like that.
okay, all right. Well, I need to go. I'll send an email out, but what I expect to get soon would be case law on bad hypotheticals from the defense and from the state, an outline of what the doctor's testimony would look like, and not so broad brush of, well, they'll talk about mental health, but some pretty specific things. So we get a sense of whether there's even going to be a collision with some of these materials that raise the defense's concerns.
And I'll get those hypothetical cases to you probably tomorrow, but if not by Monday.
All right, excellent. And keep the witness list information flowing, please.
Yes, Your Honor. Thank you.
All right, see you guys.
All right. Bye-bye.
Bye, Mr. Lowe.
Bye, Mr. Lowe.
We'll give you a call later, okay? Next week, not today. Okay.
All right, thank you, sir, for being in the room with Mr. Lowe.
No problem. Thank you, Your Honor.
All right, take care.